a particular date. Please ascertain who are your other sides. Please have a consultation with them. And because it is at the instance of the appellant, he has to come and tell us, na?
Since the interim order is there, my lord, we are suffering.
Interim order is there, you are suffering. What did you do for so long?
My lord, this matter is hard for so long
Very good.
period.
It has been assigned to us today.
My lord.
We will hear the matter, but subject to all of you agree to a particular date, we will keep the matter on that date and hear it out. Please ascertain and come back with a notice on Monday.
My
Yes.
lord, if we sub notice on today, my lord, should I come tomorrow? My
You
lord?
can ascertain, you come.
My lord.
But you please inform your appellant. The appellant has to come and mention before us. You
My lord.
inform the appellant, because if it is fixed also, again it will be adjourned.
My lord.
Please understand the difficulty. You take them into confidence and mention that when you want the matter to be heard. We will hear of that. Give a notice. Yes, next.
I'm seeking leave of my Lordship Justice.
Wait, any other mentioning in this bench?
Yes, my lord.
Yes.
My lordship directed to file paper book in a matter within 4 weeks, my lord. My lord, I'm beyond time. I was only seeking your lordship's
So original side or appellate?
appellate side, my lord.
So there is no formal extension is required. You file the paperwork in the department, survey copy, and then mention before us.
Good.
Subject to correction. As far as we know that original side extension would be required, but in this case, you can file it within that. Come and tell us on Monday. Yes.
I am a class 9 student of a CBSE school, appearing through his father in person. My education is going to be stalled unless it is hard. It is a case of
Are
assignment.
you an advocate?
No, sir.
You are not an advocate.
No.
So,
Not a practicing advocate, though lawyer.
so who did your matter? Which advocate did your matter?
I don't have. I'm in person.
I'm for the school. Person appeal.
A school matter.
Your son is student of
Assignment.
which school?
The appeal was
Your son is
South Point High School, class 9.
Uh,
And school has issued a transfer certificate, and it was an order was passed in appeal. The TC has been kept in abeyance till the result is published. Result is going to be published tomorrow, and then the transfer certificate will be reinstated with retrospective effect from 8th February. Then my son has appeared in the examination, and everything will be.
He's the appellant. Who
He's
is
the
the
appellant.
appellant?
The minor son is the appellant,
You are the
minor
appellant.
petitioner.
So you are
And-
South Point.
On South Point.
Huh.
This is a review petition, Lordship. A review from an order passed by Justice Tandon. Lordship,
Yeah.
Justice
I approached
Justice
before the
Boston
OSD of Chief Justice for assignment to this court, and a member of this bench should be your lordship. Sorry, his lordship Parthasarathi Chatterjee. And it is so urgent that tomorrow the transfer certificate will be reinstated. If not, kept in abeyance is
Sir, it is
extended.
a review application.
Review application.
Review of whose order?
Justice Tandon.
Justice Tandon and Parthasarathi
Sitting with Justice Chatterjee.
Chatterjee.
No. What?
This court.
কি বলেছে কার্তিক?
This court. I approached before the OSD to the Chief Justice, and this has been assigned to this court. The bench to be constituted along with Honorable Justice Parthasarathi Chattopadhyay. If it is not heard today, or extension is given, kept in abeyance is extended to a further period, and her matter is disposed of, the review petition,
The result will be declared tomorrow.
tomorrow itself, and the TC will be reinstated with effect from 8th February.
Lordship, the order was passed on 18th of February 2025, giving liberty to challenge the TC. Now, after 2 months, he was waiting for the 2 months. He did not throw a challenge to the TC. Now he comes and says that there is an urgency. This is the order
No,
passed by the Honorable
I have
Chief
filed that. I have
18th
filed
February
review
order.
petitions long
18th
back.
February order. There was a liberty. Lordship, kindly see.
No.
internal page 3.
I have filed this review petition long back.
Internal page
It was
3.
twice mentioned
Second
before,
paragraph.
once before Lordship Tandon, and after that I
Lordship,
mentioned it
kindly see
before the
internal
bench
page
of
3, second
Justice
paragraph,
Mantha.
the last line. However, it is open to the appellant to take appropriate steps in the writ petition in the event the appellant intends to challenge the transfer order and it is open to single bench to pass an order as and when the situation so warrant. Neither he approached the single bench nor he challenged
Actually,
the transfer order.
Wait now,
No, no.
wait.
CBS one.
So his transfer certificate was challenged in the
No.
writ.
The transfer certificate is not under challenge the writ
So
petition.
what was the challenge in the writ petition?
The challenge in the writ petition was
Department of from
If
the
you
class.
talk too much, we will release the matter. Take your seat. Take your seat.
the challenge in the writ petition was a decision of the school not to allow the student to participate in the classes, only the classes, not the examination, because he has been not paying the fees since March 2024.
Very good. Then what did the writ court say?
The writ court said that the matter will be heard out. Affidavits direction were given for filing
So
affidavits.
he was challenging your act of not allowing him
Him
to participate
in the classes, but he has been allowed to participate in the examination. He has sat for the examination.
Then when the writ petition was moved, did the transfer or TC was issued?
No, during the pendency of the writ petition, certain events unfolded. My learned friend,
Very good. He did not challenge it. Now
did
the
not
writ
challenge.
court was inaction was you are not allowing him to take the classes.
Yes.
In that the court in the appeal said he would be at liberty to challenge the TC,
TC.
which has been subsequently issued.
subsequently issued during the pendency of
Achha,
the
very
writ
good.
petition.
Now the results have been declared.
Not
But
yet, tomorrow.
tomorrow results will. So what he is apprehending?
He is apprehending that after the results are declared and the new classes start,
Ah.
he will not be, his son will not be allowed to participate in the classes.
Achha.
Because he has already been issued a transfer certificate. That has to be challenged.
পার্থর সাথে কবে বেঞ্চ আছে?
My lord, actually, we have discovered
কি
the
করবে এই যে
CBSE. May I be allowed to? May I be?
বুঝবে, সবই বুঝবে। Yes.
Assignment order টা কত?
21-22 তারিখ কোনো নেই। 25th আছে। 25th Friday। 21 তারিখ, that is on Monday। পার্থর সাথে কি 2 PM?
According to the order passed, the TC will be reinstated with 8th February.
Why didn't you challenge it?
Division bench order passed.
So come on 21st, you ventilate your grievance, we will consult
Not extended.
on that date.
If
What
the
extension?
period of kept in abeyance,
What extension you want?
extension of stay on the transfer certificate. It
Where is the
only-
stay on the
only up
transfer
to
certificate?
tomorrow.
There was any stay on the
There
transfer?
was a stay
Ah,
in
stay
the
on the
time the
transfer
result
certificate.
is published.
Huh?
There was a stay
On the
till the
transfer
time the result was published.
status is going.
The
to be
order of
published.
transfer shall be kept in abeyance till the result is declared by the school authority. Internal
is going to-
Transfer means the transfer
Transfer
certificate, TC,
TC.
shall be kept in abeyance till the result is declared.
Actually,
So very good. Result will be declared tomorrow.
tomorrow.
So
Yeah.
next class will be on 21st.
Ah.
So 21st your matter will.
First, তো আমার তো ট্রান্সফার সার্টিফিকেটটা আবার রিইনস্টেটেড হয়ে যাচ্ছে।
Should have challenged
ট্রান্সফার
that.
সার্টিফিকেট তো রিইনস্টেটেড হয়ে যাচ্ছে।
So then what
কালকে-
happens? Reinstated
তাহলে-
বলে কি হচ্ছে?
তাহলে কি হচ্ছে 8ই ফেব্রুয়ারি থেকে রিইনস্টেটেড হলে আমি যে পরীক্ষা দিলাম সব তো রিডান্ডেন্ট হয়ে গেল। পরীক্ষা তো দিয়েছি তারপরে। আর সিবিএসই একটা সার্কুলার আমরা পরে ডিসকভার করেছি, ক্লাস 10 এ কোনো ট্রান্সফার হয় না। ট্রান্সফারে কোনো অ্যাডমিশন হয় না ক্লাস 10 এ।
No such circular by the CBSE.
আমি ইনকর্পোরেট করেছি আমার রিভিউ পিটিশনে।
Alright, very good. We have to hear.
অসত্য কথা বলছে।
পার্থর সাথে একটা কালকে কি বেঞ্চ আছে?
এই যে আমার কাছে রিভিউ পিটিশনটা রয়েছে।
কালকে একটু তাহলে পার্থর সাথে কথা বলে নাও, যদি 2টোর সময় বসে আমরা tomorrow 2 PM we shall sit with Justice Chatterjee.
Sure.
Yes.
I'm grateful, Your Lordship.
My lord, may I be permitted to mention one matter, my lord?
That is over. Yes.
My lord, I'm seeking leave of my lord Justice Mitra's leave to mention a matter
What
before
you are
the
mentioning?
Dr.
My
Wood.
lord, inclusion in the list.
Come with a notice tomorrow. You have served your notice to others.
Yes, my lord.
Where is it? That you will mention today.
Yes, my lord.
Give us, show us. No notice. You are appearing for whom?
All India, my lord.
Yes, what is the problem? What is the pressing urgency? You have been asked to keep 6 posts vacant.
Yes, my lord. We have filed a appeal against the order of 15th passed by Justice Sharma Bhattacharya.
Affidavits have been exchanged.
No, my lord.
Then?
The order that has been annexed here, they have filed a writ on the previous date, on the last date. But we have filed an appeal previous to that. We are praying
So
to.
where is your completion of affidavits? Have you completed your affidavit? Have you filed the affidavit?
No, my lord. In this matter, we have not
Then
completed
how
till
can
now.
it be added? That was the order passed.
My lord,
Affidavits have been called for, time was fixed, and the matter was directed to appear in combined monthly
but
list of July.
this is the writ petition. The other side has been filed, and we have filed an appeal
We
against
don't
the
know that. You have preferred an appeal against which order?
15th. My lord, the date is inside
That is
passed
under
by.
challenge in
Yes,
the
my lord.
present appeal.
Yes, my lord.
So you were directed to file paper affidavits. Have you filed affidavits to the application?
Till now, not filed, my lord.
Then you file, it will be, is directed to appear in the monthly list of July. It will appear in the monthly list of July. Yes.
My lord,
July te rekhe diyo oita bol. Yes.
may I mention this matter? My lord, this review application, my lord would recall the review application made in Rajiv Brahma versus State of West Bengal Lordship.
Uh-huh.
The review application made in Rajiv Brahma versus State of West Bengal Lordship.
That came before us.
It was last heard on
Wait,
13th.
mention,
13th.
come next week, then we
Lordship, it was last heard.
It
Lordship,
has been assigned to myself with Justice Partho Chatterjee.
Partha Chatterjee,
So
Lordship.
when the bench sits, you mention.
Lordship, it was last heard on 13th January, Lordship. In the meantime, Lordship, in the interim, the fourth counseling has already been concluded, Lordship. Although 4,000 seats remain vacant, Lordship. Unless these matters are urgently, my Lord.
Come and mention when I sit with Justice Chatterjee. Yes, call the list. This is a service matter. Now, what happened? Your stay application, what happened?
Lordship, we didn't press the stay application at the time of admission of the appeal. No such
And 1 and 2 was allowed.
allowed. Lordship, presently, probably the CAN application in connection with MAT 423 was not disposed of, as because on the date of restoration, the said
This did not appear.
was not appeared, and the file was not also there, Lordship, in the court.
তারপরে আমরা রেগুলার
না আছে তো মনে হয়।
অ্যাটাচ করা থাকবে তো ফাইলের সাথে।
So what is the application in connection with?
Immediate Lordship, that was also a restoration application.
That was also restoration.
Restoration application. As because both the matters are tagged with each other.
As far as the item number 1 is concerned, 472.
Yes.
In that matter, the issue relating the writ petition was dismissed on the ground that the Honorable Calcutta High Court doesn't have the jurisdiction, territorial jurisdiction, because everything happened in Hyderabad. Against that order, my learned friend's client,
What was the challenge in the writ?
it was regarding seniority and promotion.
I see.
That was the thing.
So writ petition was dismissed on jurisdiction.
On jurisdiction point.
Very good.
That
And
is
the other,
the other one is when he has challenged the other application at that point of time, other writ application, at that point of time, IDBI Bank has been privatized because the share has been sold by the government. That 51%, though learned single judge was kind enough to hold that IDBI Bank no longer remains an article state under Article 12. So that matter has been challenged by my learned friend's client. On the earlier occasions, the Honorable Court was kind enough to observe, unless the territory, unless the character of state under Article 12 is there, then how the writ will be maintainable, or the order will be implemented, if at all in favor of my learned friend. So that's why the second one was taken up first, as the character, if the character goes,
then jurisdiction issue does not.
come.
Now, very good. Now, in connection with that appeal, there is a restoration.
But in both the matter, there was a
restoration. Matter has been restored. Paper book has been exchanged.
Oh, paper books have been exchanged.
Have been, all are there.
Then why it is appearing under application?
Lordship, as because your lordship on the last occasion directed the matter to be appear under the same heading.
Oh, achha.
That's why.
One respectful submission subject to lordship.
So, was there any direction for the analogous hearing direction?
Analogous
was there?
hearing. Initially, both the matters were tagged by Honorable Justice Shubhodar.
So there is no pending application in both the appeals.
Only one respectful submission subject to lordship and approval. So far as 472 is concerned, the first one, FMA 472, in that matter, Honorable single bench was kind enough to dispose of the writ application on the basis of a supplementary affidavit filed by the bank. That doesn't form part of the paper book filed by my learned friend's client. So may I?
That was not as per my instruction. No such supplementary affidavit was handed over.
In the order it is quoted. In the order it is quoted. If your lordship kindly take the trouble, 472.
Supplementary affidavit filings. So that supplementary affidavit is in MAT.
MAT 472.
No, that is FMA 470.
Sorry, FMA 470.
Very good. We will record that paper books have been filed and fix the matter for hearing. And the supplementary affidavit which has not been used, please make a copy for him and give it to him. And prepare 2 copies for us. Because if again there is a direction for supplementary evidence, then it matter may be delayed. আমাদের combined list এ কত মনে হয়েছে?
আমি দেখেছি, আমি পুরো তন্ন করে খুলে গেছি।
A composite paper book has been filed.
Lordship.
Or separate?
No, separate. Separate paper.
Then why the earlier order was passed in respect of only FMA?
Lordship, as because on that day the file was not placed before your lordship. That's why
we have been informed by the learned advocates appearing for the respect
Lordship, with regard to item number 3, Lordship, on previous occasion, I have appeared for the private respondent number 8, Lordship. Thereafter, I have tried contacting the client, Lordship. They chose not to contact, Lordship. Once I see they have received my call and said I don't have to appear on behalf of them, Lordship. As an officer of court, it is my duty to inform the court, Lordship. So, your Lordship may kindly allow me to retire from this brief, Lordship, as I don't have any instruction to appear.
Your Lordship, that I should serve upon the advocate of the private respondent.
You are Dipayanda.
Dipayanda, yes, your Lordship.
So your client's appointment is under challenge.
Yes, your Lordship.
এই জন্য আমরা চেষ্টা করি notification হওয়া আমরা হারিয়ে দিই যা শোনা যেতে পারি তারপরে তো আমি একটা দিচ্ছি তাই কত রেকর্ড দিতে পারি
Lordship, it relates to the engagement of an ASHA worker pursuant to the mandate of a notification which was published by the state respondents, claiming that in case there a particular village earmarks a majority population of scheduled tribes or scheduled castes, preference should be given to such candidates. Now, your Lordship, my contention was the particular village Polash.
Very good. No, 8 is now presently working.
Lordship,
The private respondent is present.
in employment.
He is in employment. So yes, Mr. Why didn't you intimate to him? He is your employee now.
There is no direction so far. Your
Lordship,
Lordship
You were present.
directed the
On last
private-
They have already appeared. They were
Sub copy
represented
of
Who
by
has appeared?
respondent number 8 was earlier represented by my learned friend. Thereafter, pursuant to your Lordship's direction, we had tried to communicate, but he had received instructions from the respondent number
Show
8.
us the instruction.
Lordship, I have received oral instruction over phone, Lordship.
So how can we bank on that and say you ask your client to give a written instruction?
They are not giving many.
They have not even appeared in the single bench, your Lordship. Lordship, the appointment was given by.
Where is Shishanno Bandyopadhyay?
He is engaged in code number 14, my lord.
And you don't have any instruction. Have you seen the brief? Have you seen the earlier order?
Yes, my lord.
So he is working under
SDO,
which respondent? Your BDO.
SDO Raghunathpur, Purulia.
So SDO Raghunathpur is your client.
Yes, my lord.
So he is working where? Under which sub-center?
Bedia Subcenter,
Area
Village Polash Pahadi.
Subcenter village Polash Pahadi.
Then why you are not asking your SDO to intimate? He's an employee under you.
Please direct us, my lord. I shall, my lord, intimate.
Lordship, even in the single bench, they have come
I
up,
have seen, sir, but it
come
is
up
a
with the,
question of
even in the
taking
order,
out
even in
the
the
understand.
order, your Lordship, this
Our
the
stand is
contention
very
was,
clear, my lord.
the contention was that the particular population in that particular village.
What my learned friend is
Yes,
contending that
you are, if we find that your matter is meritorious, then we will understand.
Lordship, kindly have a look into the appeal, memo of appeal, the impugned order. It is apparent from a plain reading of the aforesaid notice.
Yeah, just where you are reading.
Lordship, the last 2 pages of the appeal, memo of appeal. I have annexed the impugned order.
Yeah, give us 2 minutes. ওকে চাচ্ছে ওটা তোমাকে নিয়ে সামান্য যাবে না দেখছি এটা নিশ্চয়ই করো
Application. That's the notice for engagement at order.
21 of the
What? My appeal, my memo of appeal. Not memo of appeal.
Your-
One. Yes. Yes. Page 21. Yes. Come to the 5th eligibility criteria clause. Yes. Area village where the majority of the population belongs to SC/ST. Preference will be given to the candidates from the category keeping the selection criteria fixed by the subdivisional level ASHA selection committee. Now, what is this majority that you are ascribing? Lordship will kindly comes to page because the state in the trial court before the single judge said that this contention of the respondent number 8 was misconceived. Lordship. Now, what is this majority that you are looking at? Lordship, the majority in terms with the census report. The census report we have, and your Lordship, they have already admitted that in that particular village, the majority of the ST population is 9%. 60.33 in their report. Who has the state respondents? Lordship, page 7, para 7.
which one you are referring?
Affidavit in opposition of the supplementary affidavit, your Lordship. Yes. Respondent number 5. With reference to paragraph 33. 60.33. Lordship. So, then they should be covered under this notification. Lordship. My candidate is covered because 60.33 is the ST population. Where does this respondent number 8 hail from? The one whose job will be affected. Where does she hail from? She doesn't. Same village key. Same village. Same village. But she is not a member of the SC and ST. That is my contention. My candidate, the petitioner, is a scheduled tribe member. Your candidate. Lordship. And this lady? General candidate. At least not an SC or ST. Roy. Hadi or Roy?
কোনটা দেখাচ্ছে তোমাকে স্টেটে
Opposition to the supplement also 60.6.
where are you referring that report? That is page?
Page 7.
Page 7, your Lord.
Para 7 of the affidavit in opposition of respondent number 5. It is supplementary.
Should I read out your Lordship?
Page.
Page 7, para 7.
Yes, read.
With reference to paragraph 5, 6 and 7 of the said application, I do not admit anything and deny and dispute each and every allegation made in paragraphs under reply 7 except those which are appearing from the records. I categorically deny the statement that the appellant is a suitable candidate for the post of ASHA worker. I also categorically deny that the statement that as per census report 2011, Bedia subcenter under Gorshika Gram Panchayat with Shaturi development block of the Polashpahari village is an ST majority village areas, and the latest data shows that the ST population is 60.33%.
That is, I am denying.
No, it is an admitted fact.
Will you keep quiet and sit? Now this 60.33 is the ST population of which area?
Of village Polashpahari. kindly comes to the
It is,
supplementary
it is
evidence.
Polashpada village, or it is the Bedia sub-center is situated where?
Lordship, under one sub-center,
No,
there
no,
may
let us
be multi-
understand. Let us understand. You have referred to us the clause.
para 25 my application, page 25 of my application.
Let us read together. Page 25
25, your lordship,
of your
of my stay application, can 1. 26, your lordship,
26 to nahi hai bhai.
of my can 1, your lordship.
No, no,
First R7.
first you read page 21. What is the condition? Area within bracket village.
Village.
So what does it mean? The area is a part of the village, na?
Lordship. But it should
Your
be,
sub-center is in which area?
Lordship, under one sub-center, there may be multiple villages, more than one village. If your Lordship kindly comes to my application, page 19, there are certain sub-centers which holds more than one number of villages.
And what about Bedia?
Vedia, there is only one village.
Where do we find?
Page 19 onwards of the can.
Yes.
Lordship, page 20. Name of the Gram Panchayat, Roshika, sub-center Vedia, village Polash Pahadi.
Where you are reading page 20?
Page 20 of my can.
Yes.
Second last line, your lordship.
Hmm. Name of sub-center is Bedia. It is at Godalika Panchayat, Gram Panchayat. And block is Shanturi. Name of village is Polash.
Polash Pahadi. Now, your lordship, if your lordship will come to the supplementary affidavit on behalf of the appellant petitioner, my supplementary affidavit.
Now, first tell us what is your interpretation. Your
My interpretation is that,
of
your
this
lordship,
clause.
as per the notification,
That is page 21. As per the notification, area stroke village,
lordship,
where the majority population belongs to, is a preference will be given to candidates from that category.
yes,
So your is Bedia sub-center.
village
In the
Polash.
village of Polashpur.
Lordship.
Polashpur has several sub-centers.
Vedia has several sub-centers. Vedia has several villages. Sub-center is the genre. Under one particular sub-center, there may be multiple villages. Opposition.
Bedia has comprises of several villages.
Lordship, I will bring your attention to page 20, top. Lordship, under one sub-center, again there are more than one villages. In sub-center, Bedo,
Where you are
page 20 of my can application.
Yes.
Sub-center Bedo, the name of the village is
Potash Pahadi. You have shown us page 20.
Lordship.
20, you have said the name of the, this is the block-wise Aza vacancy details under Raghunath. This was published by them.
Lordship.
On 18th of April 2022.
Yes.
And when was the notification?
Notification was
21st of April 2022. Checking on behalf of the Raghunath who submitted.
Sub-center. It could also the supplementary.
Invited that repeated from prospecting for engagement at Assam. At the top, please read
Page
the
19
first.
onwards, your lordship.
Uh-huh.
Page 19 onwards. Sorry, 18 onwards, your lordship.
So this was 18th of April 22, which you are showing. This was annexed with 21st April 22.
Lordship. If your lordship will come to page 19.
Now, if Beria is one subcenter which has several villages.
Not Bedia, there are also other sub-centers.
Now, this Beria has no
Other village, only one
only
village.
one village.
Only one village.
Where do we come to know that?
Lordship, from the
Page 20.
page 20, kindly comes to page 19 also. I will show.
Yes.
Sub-center Ranipur, your lordship. The last, at the bottom of page 19. Now here,
Sub-center Ranipur.
Shulogna, Ranipur.
Very good.
Then Shulogna, Lakhiabad.
These all have the.
That is
So
exactly
in
what I am on,
Ranipur-
your lordship. If the particular sub-center Bedia would have comprised of multiple villages, in that case also the vacancy should have been published village-wise. Because they are specific to the village with respect to which the vacancy arises. There cannot be a general vacancy for all the villages under that particular sub-center. So Beria is one village. Beria only sub-center. Under that sub-center, there is only one village. However, according to the list, there are certain sub-centers which earmarks vacancies for multiple villages.
Very good. So according to you, Beria is a sub-center which has correspondingly one village.
With respect to which there was only one vacancy.
In respect of sub-center Beria, there was one village.
No, there are 5 villages.
In Beria,
Beria. But the vacancy arose only with respect to that one particular village.
Where is that? How we will know?
Lordship will kindly comes to page 19. I am showing you.
19.
19.
No, that is an analogy we are trying to draw.
That is exactly. Otherwise, your lordship, they would have categorically stated the number of villages with respect to which the vacancy arose.
Beria at a sub-center we have different villages. But this Beria sub-center in respect of which vacancy arose. Beria to the other places. Many villages. No, now the vacancy which arose was pertaining to the village
Polashpadi village.
Where do we find that?
Lordship, it appears from the notification.
No, appearance will not help. Tell us what material you have to show that the vacancy occurred only in respect of Polashpur.
The impugned order shows itself.
Which order?
The impugned order against which we have come up in appeal
Yes.
kindly comes to the impugned order. The state, it appears that 10% of the entire population in the concerned village belongs to SC/ST. The state respondents never took the plea that it is the average population of that particular subcenter which has to be taken into account, consideration. Even the impugned order earmarks, your lordship, that it is the village in that particular
according
village.
to the state, the village of Polashpur has 10% of the entire population is SC.
Which was a wrong.
Why you are saying it is wrong?
Because, your lordship, the census report says that it is 60.33%.
Come to the census report.
Lordship. Page 18. Page 18 of my supplementary affidavit.
Yes. Yes.
Lordship, caste factor.
Page 18.
Page 18.
Yes.
In Polashpahari village, most of the villagers are from scheduled caste and scheduled tribe. Scheduled tribe constitutes 60.33%, while scheduled castes were 29.75% of the total population in village Polashpahari. This is the census report which is published by the.
But sir, where do we find that the vacancy occurred in respect of Polashpur? Where is that? You are trying to support that contention by saying come to page 18, which will show that in respect of a particular subcenter, there were multiple villages. The advertisement was area within bracket village.
Village.
Now, what is their stand in their opposition? Very good. As per your census, Polashpahari village has a population of which majority is SC/ST. This you are banking on a certificate issued by whom? This contains no signature, no particulars. From where did you get it? Did you annex this in the writ petition R2?
Even the state respondents had duly admitted. Where? I will come. Page 7 of the opposition to the supplementary. Affidavit in opposition to the supplementary. That's not an admission, that's a denial. 40.33%. Please read the sentence. It says, I categorically deny. I do not admit anything. Reading that as an admission.
No. I categorically deny the statement that as per census report.
Lordship, the census is the as per. It is the subject matter of the union list, your lordship. The state cannot.
So your argument is Beria subcenter, the vacancy arose in respect of
only one village.
Polashpur village.
Polashpahari village.
Polashpahari village under Beria subcenter.
Lordship.
Where do we get that?
Lordship,
your argument was subcenter has different villages. You have supported your condition by page 17. That's Santuri or something. You will find 3 different villages. That is an analogy you are drawing.
Lordship, then the notification should have clarified that it is the average population of that
No,
particular
then let
subcenter.
us see. Let
The
us see.
notification was very clear. That the
Notification is area village. The area in respect of which the vacancy occurred was Polashpur. That is an admitted
Okay.
fact. Now, Polashpur village has a
it never said that it should be according to the average population of that particular subcenter.
where is
Otherwise,
according where is the Polashpur
Palash Pahari village.
Pahari village? Did they admit that the majority is not SC?
Lordship, first of all,
You are SC.
I am an ST, scheduled tribe.
So according to the state, what is the population of SC in Pahari? What did they say in their
They
show
said
us that page, please show us that page.
Lordship, kindly give.
It confused. Is having less than 50%.
Census.
Was published in the তাহলে ওই সেন্সাস রিপোর্টটা কি?
Since when has this person been in service?
Lordship,
Since when has this person been in service? The respondent number
since 2022. 22 on.
কোথায় দেখালে এই স্টেটমেন্টটা is page 20.
কেমন estimate?
It's 20 কি বলছে? Census of India 2011.
Lordship will kindly comes
Yeah,
to
yeah.
page 6. There is an admission. There is an
Yeah.
admission, Your Lordship, by the state respondents. Page 6 of the affidavit.
Just a
আমি বলছি তোমার
পেয়েছি কোথায় এসসি এসটিটা কোথায় দেখাচ্ছে?
বলছি আমি দেখেছি এই
এসসি এসটিটা কোথায় দেখাচ্ছে?
উপরে
নেই তো।
পরের কথা সেকেন্ড প্রাইস সেটা তো বলছি
সেটা তো আগের কথা। এই পলাশ now disputing, you are trying to reinterpret the clause which is there in the advertisement. So the court has called for affidavits. You are placing reliance upon Polash Pahari population R2. R2. This R2 along with voters
Census report.
report. Now, Mr. Bandyopadhyay, kindly see.
And Soumik Ghosh. Your
Sorry, Mr. Ghosh. Now their opposition, they have disclosed their stand.
Lordship.
They have replied to that page 20. No? Page 20. No. Page 20 to 20. Achha, what is your other argument? Say, this Polash Pahari population, this admission we don't find. Now, what did they say in supplementary? This is your supplementary, no? Achha. What is their opposition to supplementary? What they have added? Yes, what
Now, if
more?
your lordship goes into the impugned order, there is no averment by the state respondents that it is the average population of the particular subcenter which has to be taken. Even they have considered to the fact that the population in that particular village comprises of STs below 10%. They cannot cultivate new grounds in the appeal. Kindly looks into the impugned order.
This respondent number 8 is a general candidate.
General candidate.
On the basis of figures furnished by state, it appears that less than 10%. As such, there is no merit. It appears that less than 10% of the entire population in the concerned village.
Their population is 9%.
Area is not a village. Of the concerned subcenter.
এখানে গন্ডগোলটা হবে এই যে নেম অফ ভিলেজ বেরিয়ে গেল এই জন্য এখানে
ও বলছে it appears 10% of the entire village in the concerned village belongs to us.
So we are less than 10%.
কিন্তু এখানে ওরা দেখাচ্ছে পড়াশোনার মেজরিটি হচ্ছে
Majority is what the 6 ম্যাচ করছে
তাহলে এই অ্যাসাইনমেন্টটা তো রং।
গন্ডগোল পাচ্ছি নেম অফ ভিলেজ বেরিয়ে দিয়েছে ও সেটার বেসিসে এই 9%।
এটা কোথায় তুমি পেলে?
হচ্ছে opposition of the respondent number 5. Page 27. Lordship, even the census report which is relied upon by the petition appellant matches the census which has been disclosed by the state respondents. I will show on record.
Show us.
Lordship, page 23 of their affidavit in opposition. Of their supplementary affidavit in opposition to the supplementary affidavit. Yeah, that is what you were saying. Lordship will come to page 22. We have seen that, Mr. Moore. It is perfectly in accord. It concedes the
page.
What I was asking.
Supplement affidavit in opposition to the supplementary affidavit.
Lordship.
You are showing page 22.
22 and 23.
Very good. From that it shows majority is SCS.
SCS. And that matches the document which I have relied upon, the census report. This is part of the census report.
Subcenter, there may be many villages. Palashpur is one such village.
Distribution type has to be qualified with each village. No problem. Everything fine.
It's big, I think it's less than 9.
First of all, your lordship kindly come to the, my supplement affidavit in opposition to the supplementary affidavit. Page, my lord. Page 9. Page 9, the annex, which my learned friend also relied on. Everywhere this has been. This is the original advertisement. My lord, may I read? This is
Supplementary affidavit in opposition. You are placing reliance upon supplementary affidavit in opposition.
No. Affidavit in opposition to the supplementary.
Right.
Page 9. The memo dated 21st of April 2020. Notice for engagement of ASA. On behalf of the ASA Selection Committee, Raghunathpur Subdivision, applications are hereby invited in the prescribed form, that's Annexure A, from the prospective and interested candidate for engagement of ASA on purely voluntary basis under NHM for different areas, not for the village. Your lordship, kindly pause here for a minute. For different areas, not for different villages. Different areas under the health sub-center. So it is under the particular health sub-center. There are certain areas which the health sub-center covers. So under a health sub-center, there may be 2, 3, 4, 5, 6 villages. Under Raghunathpur 1, 2 and Saturi. So this advertisement, my lord, particular engagement has been done under Saturi. Saturi, my lord. Then your lordship. Saturi.
Yes.
Then your lordship. Time and again, my learned friend has tried to confuse.
These areas under all health sub-centers, under Raghunathpur 1, Raghunathpur 2.
Nituria, Saturi, Para.
So there are 1, 2, 3, 4, 5.
There are 5. These are all, my lord.
Block primary health center.
My lord. There are sub-centers. Also, here there are sub-centers to the health centers. My lord, your lordship, kindly come to, my lord, page 13.
Page 13.
At the end of the, my lord, block medical officer of health, block medical Saturi. His signature is there. My lord. Now he has clarified the position to this SDU.
Yes,
I am reading, man. As per the email received on 2/5/25, 6/2/25, by memo number such and such, the information sought for from your end regarding furnishing the detailed service areas of Beria sub-center. This engagement has been done under the Beria sub-center, under Saturi block. So sub-center is Beria. Under Gorsika Gram Panchayat, under Saturi development block, it has been cross-checked from the different public health register of Beria sub-center, which are used solely for the purpose of providing healthcare facilities, and various health portals and various sub-center comprises Beria, Gorsika, Palas Pahari,
Miti Tundra, Dolanbor, and Kulai.
So these 5 names which have been
These
given.
5 names, these are the villages covered by the various subcenters, in which one of the village name is Polaspa. But subcenter has to be established. In 5 villages, one subcenter cannot be established. So among these 5 centers, one of the villages, there is subcenter has to be established among the 5 villages. So in Polaspad, the building of the subcenter is established. But it caters the need of various subcenter that scattered in 5 villages. An ASA worker has been appointed
Caters the
various subcenter in general category. Now, your lordship, kindly come to page.
Your argument is that Bedia subcenter is comprising of 5 villages, amongst whom Polashpur is one.
Of them.
So in Polashpur, the subcenter building is there.
Building is.
So now, as per your advertisement, the area. Let us come back to the advertisement. Advertisement area village.
Yes.
Page 9.
My lord.
Area stroke village where the majority population is SC/ST.
Yes, my lord.
So
now, areas and villages. That means 5 villages. The area covers. That is among the 5 villages, various subcenter covers, and among the 5 total population, ST population of the 5 villages is less than 50%. Now, your lordship, kindly take the affidavit in opposition I have given to the stay application. Page 27.
No, before you go to that, show us that the village Polashpur. Polashpada.
I'm coming to that. That's why I'm referring this page, madam. Page 27 of my affidavit to the stay application. Affidavit affirmed on 12th day of June 2024. Page 27. Page 20. I have given a tabulated chart.
Yes.
That is, your lordship. Name of the village GP is Gorsika. Subcenter is Beria. Name of the block
Page
is
27. Page 27 you are reading.
Page 27.
It bears no endorsement, no seal, nothing.
I have received
literally
this is this
typed copy.
From the, my lord, your lordship, kindly come to, my lord, page 27. To Gmail, they have sent it to the, when I asked the department to send it.
Yes.
My lord.
What you are saying? Block Shanturi.
Block Shanturi, name of the village, my lord, Gram Panchayat Gorsika, name of the subcenter, that is Beria. Total population is 3,980. ST population is 1,884. That is, the population is 47%, 47.33%. So, Beria subcenter consists of 5 villages. That is Beria, where total population is 890. ST population is 80. Percentage of ST population is 9. Even Polaspad, your lordship, third column, third row, total population is 289, and
this is only ST. There is no SC.
There are SC because the petitioner belongs to ST. That's why we have asked the department to only send us the statistics of ST populations.
So total population of 5 villages is 3980.
3986.
The total population of ST.
Total ST population
1884.
1884.
Then
that comes to 47.33%. If I make a total and calculate. Now, your lordship, kindly come to the census report. I have annexed in my supplementary affidavit.
Now, very good. Before you come to that, then why you are writing page 27, name of the villages. So now you are
Even in Palaspahari, the ST population is
সেটা হচ্ছে 47.3 আর আমাদের অ্যাডভার্টাইজমেন্টে বলেছে মেজরিটি পেজ না majority is more than 50. Yes, next what you are showing?
Your lordship kindly come to the supplementary affidavit. Affidavit in opposition to the supplementary affidavit given by the petition, my applicant. Page, my lord. Page, my lord, 20. This is an enormous, my lord, census report, wherefrom we have taken the extract, my lord. Only first page of the report, next page of the report, and the page number 175, which is relevant, I have extracted. Your lordship kindly come to page 22. Page 22, there your lordship find the name of the villages. This is total population. Your lordship, name of the villages, second column, name of the villages, that is 2. Your lordship, from the bottom, your lordship kindly come up to
yes, Palaspahari, we have got
then Palaspahari, then Palaspahari,
5টা ভিলেজ গোয়ালবেড়ি
area,
বেরিয়া
your lordship, see Mutindra, Matitundra.
গোয়ালবেড়িয়া
I have what I have just now referred in my my lord, in page
page 27.
Page 13, I have referred the name of the villages Beria, Goalberia, Palaspahari, Matitundra, and
Kulai.
Kalanbor and Kulai. So your lordship kindly see the Matitundra 3305.
We didn't get it.
These are the 5 villages. Total population.
Let us go slow. Santuri, where you are getting Goalberia?
My lord, your lordship kindly come to the end of the my lord, at the fag end of the page, my lord. Then your lordship leave 2 lines. Then your lordship see the then 2 lines, 3 lines. Then your lordship, there are numbers. I am reading the numbers.
No, there is, we are getting Kulai, we are getting Palaspahari.
Palaspahari, then
we are getting Benria.
Then Matitunda, Gorsika.
Matitunda.
There are columns.
Matitunda.
There are name of the 5 villages are there, man. So total population is there, column 5.
এই যে
column 5.
পলাশপুরের উপরে এই যে 5টা একসাথে দিয়েছে 1 2 3 4.
Serially, there are name of the 5 villages.
Yes.
Then your lordship kindly come to the column 5. Column 5, your lordship sees the total population of the villages. If your lordship make it total, then it comes to 3,560. I have made a rough calculation here.
1 second.
This is the latest, my lord. Then your lordship kindly
3,000 it comes to
3,560.
3,560.
60 as per this report. Then come to page 23.
This is, you have added 524, 864, 242, 713 and
1,270.
This total comes to
3,560.
তোমার ইয়ে আছে, মোবাইল আছে না, অ্যাড করে দেখি।
and to page 23. 23 column 14 person, total schedule type person, column 42, 1, 2, 3, 4, fourth column. That is column 1/4.
1, 2, 3, 4.
Column 1/4 persons. Schedule type, total schedule type population. Schedule type population persons. So amongst the total that I have referred in earlier pages, this is the total of schedule type person living in the village.
146. Now 590. It is 1012 plus 252
Yes,
plus 593 plus 146.
123, 152, 593, 146, 62, and 526. This total comes to 1562. If I make it a percentage, then it comes 24.4%.
এইখানে অ্যাড করো তো এই অম্লান 52
divided by total population, then your lordship will come to percentage of ST population is 44.25 or 24%.
No.
So there is much less than the 50%.
3560 divided by 100. কত হলো 35.60 into 15784.
Four point 24 or 24%. So, my lord, this is less than 50%. That's why the candidature of the petitioners has not been considered by the department as a ST candidate. So, general the selection was done clearly on merit, your lordship. Then
all right. Then please explain to us, as per advertisement area village. So the vacancy you have earlier said vacancy in respect of those 5 villages.
That is various subcenter.
Various subcenter.
Subcenter wise.
Various subcenter has 5 villages.
Yes.
So the building
covers certain area. 5 villages cover certain area. Within that area, how much is the population of the how much is the total population and how much is the ST population? So we have calculated this from the my lord census report itself. It comes to 44.24%, and roughly department has calculated it to the 47 point something. So in both the calculation, it is less than 50%. That's why it has not been carried.
Very good. Now come to the ordered impugned.
Yes, my lord.
Internal page 2, last paragraph.
Page 2, last paragraph. Yes.
It is apparent from a plain reading of the aforesaid the same is to be made applicable to only where the majority of the population of the given area.
Is given area. So
or village.
So
my lord. So on the basis of the figures furnished by the state respondents, it appears that less than 10% of the this recording is bad then.
Yes, ma'am. It has not been correctly recorded.
That must have been the plea of the state respondents.
It is your plea, na?
Exactly. Now they cannot
are
deviate
saying-
from these.
You are
plea
saying
which was taken before the single
senior
bench.
judge, you said that on the basis of the figures furnished. So this is the finding of the court. Right now.
Exactly. এটার উপরে গেছে। বলছি যে 890
It has perhaps, my lord, a mistake has been done.
890 টা দেখা order ঠিক এইটাই বলেছে। This connection with state respondent have a chart to demonstrate that subject area various subcenter total approximately 890. এইটা পাচ্ছে এই চারটাতে।
My lord,
9%.
kindly,
That was your contention before the learned single judge.
my lord, your lordship, kindly come to page 27 once again of my
Yes.
My lord,
We are
of
on
my
page-
of
we are on
my
page 27.
here Beria is a village also. Perhaps the learned judge has construed that here the population is still 9% on.
That court has not, it is your
It's your
argument,
submission.
your submission.
Our argument, my lord, our argument may not be, my lord, correctly, my lord, stated in the correctly percolated in the order, my lord. The same argument we have forwarded in the read petition. When the read petition was, my learned senior Amitesh Banerjee was there. He has argued in this manner. I was assisting him when he was arguing that matter, my lord. So your lordship, then your lordship again come to
The area must be comprising of all the
page, my lord, 21.
একটা village আছে
Your lordship, come to page 21.
Yes, village at less than 10%, various subsection at 44% something.
Come to page 21. This is the on the basis of the merit, the selection has been
Page
done.
21.
Page 21 of the my original affidavit that has been given to this against the stay application. Page 21. There were 3 candidates. Respondent number 8 was chosen because he scored.
Who is respondent number 8? Who is respondent number 8?
Munmun Hari, who is now working as a ASA worker.
And the appellant is Promila.
Appellant is So clearly on the basis of merit, the selection was done, and the reservation was not came into consideration because the population of that area, Beria subcenter, was less than 50%. That because of that, the candidature as ST of the Promila from has not been.
This is yours. Is anything else, Mr. Ghosh?
I stick to my earlier stand. The notification was with respect to the vacancy in particular villages. There are certain subcenters with multiple vacancies in multiple villages. That was very clear in the notification. But so far as the vacancy,
So show us that.
Lordship,
I have stated it.
Lordship,
I
page
argued that
13 of the
subcenter has consist 5 villages,
page
6
13 of the
villages, 1 village.
supplementary affidavit on behalf of the appellant petitioner. Lordship will come to
Page 13
page 13
of your
of the supplementary affidavit on behalf of the appellant.
Yes.
Kindly comes to the bottom of the name of the Gram Panchayat, Shimla Dhanera, Subcenter Shimla
The way page 13 of the
of the
opposition to supplementary.
affidavit on behalf of the appellant
Op-
petition. Supplementary affidavit on behalf of the petitioner.
Supplementary affidavit on behalf of petitioner.
Yes.
Yes, page.
Page 13.
Page
That chart.
On 3. Yes, 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 yes.
Page 13.
Yes.
What you are showing?
Lordship, Gram Panchayat, Shimla Dhanera. Name of the subcenter is Shimla. Bottom of the page.
Yes.
Name of the village is Shimla.
Yes.
Vacancy 1.
Yes.
Thereafter, your lordship, it refers to the same subcenter but with another village, Gopalpur. So if I go by the argument taken by my learned friend, if there are 5 villages, the 5 villages should have spoken of specific and categoric vacancies in each of the villages. Now he cannot come and
No, he says there is only one vacancy in respect of 5 villages.
The notification does not say so. The chart doesn't say so.
This chart
It says only with respect to that particular village. Then it should have given the name of all the 5 villages.
Kindly come to page 11, Mr. Ghosh.
In one village, there may be 2 subcenter, 3 subcenter. But
that is
in
exactly
another subcenter, there may be 5 villages.
There is an what appears to us that there is only one vacancy in respect of 5 villages.
They should have given the name of 5 villages in the advertisement itself. One subcenter, 5 villages, one vacancy. They should have clarified in the chart.
That kindly come to the page 8 of your, which you are showing, page 13 you are showing.
Page
Kindly,
13 I am showing your lordship.
Kindly come to page 4. The advertisement.
Yes.
On behalf of Asha, applications are invited from and interested for engagement as such on purely basis under for different areas under all the sub-health centers. So the area here is comprising of 5 villages. The total population of the 5 villages is less than 50%. As such, for that sub-center, where there was only one vacancy, the general candidate has been selected.
Lordship, in that case, all the 5 villages should have been indicated in the notification. It was only with respect to village Polash Pahadi. Where are the names of the other villages? The notification never marks any whisper on that.
So this is in respect of which block? Shantur.
Saturi.
Eh?
Yes.
Where is Shantur at page 13 you are showing? Page 17 where you are showing Shantur? Hey, Shanturi is page 15. Now see, in Shantur there are several Gram Panchayats. Now name of the sub-center, in respect of the respective sub-centers, the vacancies have been given. Sub-center in respect of Murulia village 2. Gorshika, Polashpur is 1.
Polash Pahadi is 1.
Polash Pahadi is 1.
The
But there are other villages also.
They should have indicated that, your lordship, apart from Polash
They have
Pahadi.
They have indicated under Shaturi block. There are 1, 2, 3, 4, 5, 6, 7 Gram Panchayat. Name of the sub-center as so much. So Beria sub-center.
There is only one village, your lordship, with respect to which the vacancy arose.
Not under various sub-center, there are five villages. But in 5 villages, one sub-center cannot be constructed. So we have to choose one village where sub-center building has to be constructed. That village, the sub-center is situated at Polas Pahad, but it caters the need of the people of 5 villages, which is under various sub-center, comes under various sub-center.
Sub-center
Vacancy is one.
Sub-center area, sub area must cater to the need of 5 villages, in which one is Polaswar. A good area of more than 20% is শুধু পলাশপুরটা যদি সেটা তুই করতে গিয়ে দেখা গেছে পলাশ
Of the supplementary affidavit, your lordship comes once.
Yes.
My lord, your lordship kindly come to middle of the page. Name of the block, Nituria, last. Your lordship kindly come to the GP, Gram Panchayat. Digha, Sarbori, Sarbori. And the name of the sub-center. Sub-center is Sarbori. So there are villages where 2 sub-centers are there, big villages.
The present appeal has been prepared.
my application. I am for the appellant bank, Your Lordship.
What is Can 1?
Lordship, and one regarding stay application, Your Lordship. Lordship, the matter has been heard by the Lordship, Justice Jamal Bagchi and Your Lordship, Mr. Kant, Your Lordship, and Mr. Kant. And after hearing Your Lordship, the Lordship Bagchi has stayed the further proceeding of the contempt before the bench and fixed the hearing of the appeal, Your Lordship. And matter is appeared before Your Lordship for hearing.
So there is an operating injunction.
Operating injunction, Your Lordship.
When?
Lordship, 20th February. On 20th February, Your Lordship.
What, a disciplinary proceeding?
Lordship, actually,
That's very good. We will extend the interim protection which has been granted. You file your paper books.
Lordship.
There is a stay of the contempt proceedings, no doubt. So let me kindly hear out the matter because issue is very broad. There were two charges. Again, I was proceeded against in the departmental proceedings. The Honorable Single Bench was pleased to
dismissed.
No, the Honorable Single Bench was pleased to quash only one charge and reduce the quantum of punishment.
From?
There was a reduction of basic pay by 2 stages. It was done to reduction of basic pay to 1 stage. That is the order.
You are agreed by that?
I agree.
You are the bank?
I am the bank, Your Lordship. Lordship, actually, Your Lordship, the final order has been passed in the year 2014, Your Lordship. 14th April, final order has been passed on 14th April 2014. And thereafter, read petitioner.
14th April
2014, Your Lordship.
The punishment was imposed.
Lordship, in decreasing to down. And thereafter, Your Lordship, appeal has been preferred by the read petitioner before the appellate authority. And appellate authority has disposed of the matter on 30th July 2014, Your Lordship.
30th July.
30th July.
Yes, then what happened?
And thereafter, Your Lordship, petitioner has superannuated.
When?
On 31st May 2015, Your Lordship. And Your Lordship, the read petitioner received the entire retirement benefits after his superannuation, Your Lordship, on 31st May 2015, Your Lordship. And after 1 year and 7 months, consuming 1 year and 7 months, Lordship, on 14th December 2016, Your Lordship, petitioner, when he seems that I have agreed this order,
he challenged the
read petition, Your Lordship.
14th December 2016.
14th December 2016, Your Lordship.
Challenge the
challenging
read petition.
Challenging the order of the disciplinary final order, challenging the final order as well as the appellate order, Your
Which
Lordship.
was taken in 2014.
2014, Your Lordship. And thereafter, Your Lordship, appeal has been, read petition has been heard before the
চলে গেছে on 30th of July 2014, রিটায়ার করে গেছেন May 25, আর রিট পিটিশন ফাইল করেছে 17।
I have taken point, Your Lordship, before the bench regarding maintainability, but my submission has not been considered.
Not considered.
And they
Show us the impugned judgment
Lord,
where it has not been considered.
Page 140, Your Lordship.
and your lordship, regarding lordship, in the fact of this case, your lordship,
But fact will come later. Show us that your maintainability point was not considered. Page 140.
lordship, I'm coming that point, your lordship. And lordship, in page 143, your lordship.
Page 143.
143, your lordship.
Yes.
Lordship, paragraph 9, your lordship.
9.
Nine.
Yes.
Per contra, Mr. Jha, learned advocate for the respondent bank, submits.
Such being the position, present petition may not be held to be maintained in view of coordinate bench judgment. Then how this point was dealt with?
And lordship, I have submitted a coordinate bench order, your lordship, regarding Pratap Rai and Kolkata Municipal Development Authority, your lordship. In this judgment, your lordship, Justice Sambuddha Chakravarti has clearly pointed out that when the writ petitioner has superannuated.
Have you brought the judgment of Pratap Rai?
Pratap Rai, I have quoted this.
কোথায়? Judgment টা কোথায়? You have brought it. পুরো কেসটা ডিফারেন্ট হবে।
Actually,
You're a bank, na?
lordship, but at this stage only one.
Show us which paragraph. That is the only point, whether writ petition at all was maintainable or not.
Lordship, in page number 5, second paragraph and last.
Read out.
Lordship,
read.
Lordship, in substance, the principle on which the petitioner is struck from challenging the order of the disciplinary authority is based on the doctrine of the election. This doctrine applies to cases when a man as against another has two alternatives, but mutually exclusive courses to resort to, and he has to make an election between the two. If he, by his conduct, induces the other to believe that he has decided to pursue a certain course of action, he is not permitted to subsequently alter the stand by restoring to other course. In election, as observed by Spencer, Boer, and Turner, a man is always found comforted by a choice of two alternatives, one of which he must eventually choose to the exclusion to the other. In Re Lord Wilkinson versus Blades, reported in 1896, Chancery 788, Justice Chetty observed that a person who is fully cognizant of the proceeding and who stands by and deliberately takes the benefit of a decision under which a certain amount is disbursed is struck from
So his employer-employee relationship has ceased in 2015. What right do you have to challenge it after retirement?
So I have learned one base fundamental principle from your lordship that there cannot be an estoppel against a fundamental right.
What is your fundamental right?
Here, your lordship, the retirement benefits which I have received, if this punishment order or this order passed by the appellate authority is set aside, the disciplinary authority awarded punishment reduction of basic pay by 2 stages. Now, the honorable single bench reduced it to reduction of basic pay by 1 stage. So that will make a substantial difference in my retirement benefit.
Yes.
My pension.
Yes.
And
So
retirement.
on the day you retired, on the date of retirement, was any grievance expressed by you? Admittedly, no.
On the date of retirement.
How you cannot be deprived of a legal right. You are drawing the nexus that my pensionary benefit has been reduced. That's why my right to livelihood has been affected. On what basis you are arguing that? Admittedly, you retired on 31st of May 2015. The appellate authority order was 30th July 2014. So there was cessation of your relationship on 31st of May 2015. Now you preferred the writ petition about 2 years thereafter. What is the explanation given by you as regards the delay?
The point of delay was never taken.
And it's certainly taken. Paragraph 14, it was certainly taken. Paragraph 9.
Paragraph 9, the bank submits that the present writ petition is superannuated from service and he had received his entire retirement benefit without any objection.
Exactly.
Paragraph. Inordinate delay. Second line.
This point has been dealt with by the Honorable Single Judge, Your Lordship.
Where?
First, paragraph 14, that the judgment of Pratap Roy has been distinguished.
How can it be distinguished? In Pratap Roy, there was no statutory appeal. Writ petition was directly filed. But the basis is cessation of relationship.
Cessation of relationship in the present case, Your Lordship, accepting retirement benefit will not be a bar in challenging the disciplinary proceeding.
After your relationship has ceased.
Lordship, kindly see the judgment of the Honorable Apex Court.
Yes.
This is 2000 volume 3 Supreme Court cases 588. Paragraph 13. 588. Paragraph 13. The tribunal as also the High Court both appear to have been moved by the fact that the appellant had encashed the check through which retrenchment compensation was paid to him. They intended to say that once retrenchment compensation was accepted by the appellant, the chapter stands closed and it is no longer open to the appellant to challenge his retrenchment. This we are constrained to observe was wholly erroneous and was not the correct approach. The appellant was a casual laborer who had attained the temporary status after having put in 10 years of service. Like any other employee, he had to sustain himself or maybe his family members on the wages he got. On the termination of his service, there was no hope left for the payment of salary in future. The retrenchment compensation paid to him was only a
yes, on
meager amount
termination of his service, there was no hope left for payment of salary in future.
Yes.
On that rider, court said.
That rider, he received the retrenchment compensation.
Retrenchment compensation
Here,
has to
it is a retirement benefit. Ashok, can you see the next line? This does not mean that he has surrendered all his constitutional rights in favor of the respondents. Fundamental rights under the constitution cannot be bartered away. They cannot be compromised, nor there cannot be any estoppel against the exercise of fundamental rights available under the constitution. As pointed out earlier, the termination of the appellant from service was punitive in nature and was in violation of the principle of natural justice and constitutional right. Such order cannot be sustained. So this judgment clearly says that even after retirement, even after receiving retirement benefits, I can challenge the disciplinary proceeding if
you can subject to certain condition. Fundamental right cannot be defeated on the ground of limitation. That is a settled proposition. Yes. But here, what did you do for 2 years?
No, Your Lordship, the order. The punishment order was passed on 11th of April 2014. After that, he preferred an appeal. The appellate authority passed an order on 30th July 2014. After that, I superannuated on 31st May 2015. There was some delay. Admittedly, there was some delay. I cannot get over the fact that no, there was no delay. There was some delay. But delay in this case will not defeat my justice to file a petition challenging a departmental proceeding.
There will be no end to litigation. Unless you explain the delay to us, why should we give you that? Your fundamental rights, it is not it is a question of a disciplinary proceeding. A punishment has been modified. After modification, I accepted the appellate authority order. I got my retirement dues. I did not write a letter that without prejudice I am accepting. Fundamental right cannot be taken up for consideration at any, you're subject to your conduct. In this retrenchment, what happened? Page 589, calmly come. Appellant was initially engaged. After working, first of all, he was a casual employee. He was claiming permanent status, having rendered 10 years of service. You are a regular employee. You were conscious about the retirement benefits which were being given to you, giving effect to the appellate authority order. You accepted it, Mr. Majumdar.
I may have accepted the retirement benefits.
Right.
After that, I challenged the disciplinary proceeding.
How can you do so after 2 years?
There is a delay. There is admittedly a
Mr.
delay.
Majumdar, why should we exercise judicial review in your favor?
Because I can show your lordship now and here how biased the inquiry officer was from the very beginning. The entire disciplinary proceeding tends with bias.
You have waived your right to challenge the same on the plea that now I can take since my fundamental right is affected. This subject to correction, I don't know what you will argue.
Your lordship's correction,
This is
I
the
have
only
never
point.
waived that fundamental right. I always had the right to challenge that proceeding.
Judgment near so. Where is the writ petition? Have you annexed?
Yes, it is annexed.
Lots of writ petition, your lordship, in page number page number 33 to 115, your lordship.
Page 33.
33 to 115, your lordship.
Any explanation about the delay?
Lordship, they have made out that he is ill and his family members are ill.
Family members are coming.
He is ill only. I have, at this stage, I have.
The present appeal has been preferred.
Lordship, I am for the appellant. May Lordship be kind enough to allow Mrs. Manju Agarwal to appear.
Milord, I am appearing before Lordship virtually, Milord, on virtual mode. In this.
Mentioning kuch.
My lord, may I just?
No, I'm not mentioning. I'm appearing in the matter, Milord. I'm not mentioning.
My lord, may I just? I appear for the defendant numbers 2 and 3 in the main appeal.
Milord, I am the appellant, Milord. I'm representing the appellant here.
Has passed away during the pendency of the appeal. Now,
Milord,
Mrs. Agarwal, please let me submit. Now, way back on the 8th of February 2024, my lords had been pleased to pass an order. It is submitted that a substitution application is pending before the learned trial court, which is yet to be disposed of. Let the matter go out of the list for the time being with liberty to parties. Since 8th of February 2024, no attempt, and I say this with responsibility, has been
no,
made.
Milord, I join issue with this submission of Mr. Bose.
First, let me finish. I may be saying a whole lot of wrong things.
No,
Correct?
we know Mr. Kapoor was appearing. Thereafter, he.
And then after the Mala, no steps have been taken in the substitution. On the contrary, a spate of other applications have been moved, one of which was heard and disposed of, I think, last week on the 9th of April by my lord, Mr. Justice Shugato Mujumdar. And my lord, another application was pleased, the learned judge was pleased to release because he no longer had the matter, and it is now pending before my lord Justice Krishna Rao. Now, this appeal,
no,
my
Milord,
lord, something now, perhaps
substitution has not been filed.
Not yet taken place.
No, Milord, may I just make one submission, Milord? May I? It's my appeal, Milord.
Person before the court,
Milord,
mentioning
Milord.
not in a position to affirm, and both of you are making submissions. We are not even able to ascertain. You don't have this much of this much you cannot do. Your junior was repeatedly mentioning the matter. It was never told to us that substitution application has not been filed. And
no,
now,
Milord, it has been filed, Milord. It has been filed. With deepest respect to your lordship, it
But
has been filed.
no steps has been taken.
It has been filed, Milord. Steps have been taken, Milord. I am told, Milord, before this honorable court, as also before the learned trial court, Milord, in the suit court.
When have you filed, madam?
Yes.
Milord, it has been filed. The application here before this honorable court, Milord, I am holding. There also, Milord, we have filed. The legal heirs have filed an affidavit that they don't want to contest the proceedings, Milord. We have filed an application, they have filed an affidavit.
Question: what was the date of your filing of substitution application? And have you served it upon all?
Yes.
Yes, Milord, it has been served. I am told, Milord, it has been served up in appeal June 2023. I can see the
My
soft
respectful
copy,
submission.
Milord, Mr. Bhattacharya, Milord, let me submit.
In my respectful submission, till the substitution takes place, my lord, this appeal cannot be heard.
Yes, that is what I'm submitting, Milord. My application, substitution application, GF4, is pending before your lordship.
We have, my lord, the substitution application
has been allowed.
No,
it has not been allowed.
Pending. No steps taken.
No, it has not been allowed.
Yeah.
So excited.
The
substitution has been filed. It has not been pursued thereafter. On the contrary, other applications have been moved, which have been pursued with great
All
gusto.
applications have been pursued, Milord. We have pursued the substitution application also.
It has not been allowed.
And my lord has expressed a
Madam,
desire
how
that
can
it
we
should
hear
be
the
disposed
appeal
of
then?
first. There is no reason.
Milord, kindly fix any date, Milord. We will argue the appeal. You kindly allow the substitution application.
Without the substitution, how can the appeal be
Substitution
heard?
application has to be allowed first, Milord.
Yes, that is before the trial court. That is before Justice Rao.
That is before the appeal court also. We have filed the substitution
That is
application.
GA8 before Justice Rao. GA8 before Justice Rao.
And GA4 before this honorable court.
In these matters, it is your responsibility to ascertain from your senior that what is the state of affairs. You are constantly saying that everything is ready, my lord. The man is in his deathbed. You add it.
This is, my lord, this is the thing, my lord. My client is in the deathbed. This is correct, my lord. He is in a terminal stage. But GF4 is my substitution application. First, let it be allowed, my lord, and kindly take up the matter expeditiously, my lord. This is my humble submission, my lord.
To have your substitution application allowed.
Yes, certainly, my lord.
Take steps there and then come and mention. We cannot allow the substitution here unless
For allowing the substitution application, also the bench is required to be constituted, my lord. If my junior has not been able to explain it to your lordship, I deeply apologize for the same. However, my lord, first the substitution
let
application
them
be
take
allowed.
steps before Justice Rao. Let them take steps before
That is
Justice Rao.
that is in the suit, but in the appeal also substitution is required to be allowed, my lord. That is a different thing.
Unless the substitution takes place in the plaint, in the suit, how can the appeal be heard out?
In both the places, my lord, we are taking steps to have substitution application being allowed. The legal heirs there in the suit court had submitted that they don't want to be added as a party because they don't want to become a partner in the partnership firm. My lord, so far as this appeal is concerned, my lord, until as they are brought on record, my lord, my appeal I cannot pursue, my lord. Therefore, my lord, my substitution application should be allowed in the appeal court. There also we are proceeding, my lord. We have taken steps.
What is have you seen the order dated?
I have seen, my lord, 8th February 2024, passed by your lordship. I have seen it, my lord, but my substitution application, appeal court, trial court, it is pending.
So
we have taken steps. Kindly take up here substitution application. Kindly allow it, my lord. That is what I am submitting. This is independent of the suit court, my lord.
We will say that we will direct the matter to go out of the list as and when your substitution application is allowed. You come with a notice to other side and mention.
Grateful.
Very well, my lord. I'll take immediate steps to have the application listed, my lord, before the trial.
That by an order dated 8 February 2024, the matter was directed to go out of the list since it was submitted that a substitution application is pending before the learned trial court. Directed the matter to go out of the list for the time being with liberty to the parties to mention upon notice, since it was submitted that a substitution application is pending before the learned trial court. Today, we have been informed by the learned advocates appearing for the respective parties that though a substitution application is filed, the same is still pending consideration. The substitution is pending. He filed prior to this. You filed the substitution prior to 8th February.
Yes, my lord, prior to 8th February.
We have been next today, we have been informed by the learned advocates appearing for the respective parties that the said substitution application is still pending before the learned trial court. In view thereof, let the matter go out of the list for the present. Liberty to mention to the parties, a liberty to the parties to mention upon.
Very grateful to ma'am.
Deeply
grateful, madam.
May my presence be recorded, my lord.
Our presence is
Madam, I am being led by Mr. Mukherjee.
Appearance.
Mr. Mukherjee is leading me, madam.
Mr.
My lord, I was stuck in another court, my lord. I made my appearance while your lordships were dictating. My
lord, I am the appellant in item number 1 to 4 and the respondent in the item number 5.
Must have been.
Yes, my junior will give the appearance.
Mr. Mukherjee
Mr. Mukherjee is leading me. Yes. Grateful.
I'm grateful, man.
Deeply appreciated.
May I be permitted to mention one application on the original
Mention original site.
original site.
What matter?
It's a application in connection with an appeal, my lord, service group 6.
You are mentioning about notice.
Yes, yes, my lord. Mr. Ghosh is there, my lord. Mr. Ghosh is also here, my lord. I have already served the copy of the appeal. Thakurmuni.
স্লিপটা নিয়ে নাও, তারপরে আমায় বলে দিও ফাইলটা দাও। অ্যাপেলেট সাইডে ওটাই তো শুনছিলাম।
Your Lordship is considering appellate side matter first. Item 21.
কি ওয়ান ফন্ট রাখছে কেন?
ওইটা তো নোট টাইপ স্টাইল নিয়েছে।
21 ওটাই লিড ম্যাটার তো 21টা।
এদিকে এইটা না, এই
এখন কি দিচ্ছ না, বুঝতেই পারছি না। হ্যাঁ,
এই যে অর্ডার ছাপবে,
কে দেশে দেবেন? কাল 9টা থেকে আমি কোথায় আছি?
হ্যাঁ, আরো বল। বেশ। অর্ডার গুলো কত
নিয়েছি, ভুলে গেছি।
I'm filing my exception to the supplementary report filed by the state on last day. I have already handed over the copy to my learned friends.
একটা নোট দিয়েছিলাম, কোথায় গেল? দেখো কোথায় থাকবে, কোথায় একটা Thank you. এটা একটু আলাদা করে রেখে দিও। এটা তো নেবো, তো একটু আলাদা করে রেখে দিও। আর এইটা যে আসবে এখানটা আমি ট্যাগ মার্ক করে দিচ্ছি, ওই নামটা নেই। Yes, Mr.
But for recapturing the facts, my lord, there are two sets of cases, my lord. In some cases, MR distributors, existing distributors, have challenged the vacancy notification notified in their operational area with the proposal to delink dealers from their existing distributorship. So their volume of business will be reduced. On that ground, distributors came this court, and in some cases, fair price shop dealers came before this honorable court, challenging the vacancy notification notified in their operational area with the proposal to delink ration cards from their dealership. There are two types of cases, my lord. All are appearing before your lordship.
Yes.
But the ground for challenge in both the cases is vacancy notification has been issued invoking the provisions of 2013 control order. Just for capturing my lord, brief facts.
Just one more. Memo of appeal to wait. Yes.
In both the cases, ground for challenge is vacancy has been notified under a redundant law or non-existence law because 2013 control order has been superseded by Central Control Order 2015. So after supersession, invoking the provision of a redundant law, no vacancy can be notified. I have shown to your lordship on last occasion that National Food Security Act came into force on 10th September 2013, changing the entire concept of public distribution system. Now it is targeted public distribution system. TPDS, National Food Security Act, came into force on 10th of September 2013. That is subsequent to both the state control orders. State control orders notified on 8th of August 2013, so far the rural area is concerned, and there are two control orders.
One is 8th of August 2013.
Another is 12th of August.
12th of August.
And National Food Security Act came into force on 10th September, subsequent to that. Then, for implementation of the National Food Security Act, central government frame a rule that is called Targeted Public Distribution System Control Order 2015. Which came into force on 20th of March 2015. 10th of March 2015. 20th of March.
No, after the Food Security Act.
Then Central Control Order
of 2024.
20th March 2015. Central Control Order for implementation of the National Food Security Act, which will appear from page 227.
A Central Control Order
2000, my lord.
2015.
This is called Targeted Public Distribution System Control Order 2015 for implementation of the National Food Security Act 2013.
That is at page 221.
227. Now, two provision I shall show to your lordship.
No,
227.
This came into effect from
the 20th of March 2015.
Yes, that is at page 221.
No,
227.
227. 227.
Yes.
Two provision, if you will also kindly see from page 227. Kindly see, my lord. 20th March 2015 date. Whereas the central government is of the opinion that it is necessary and expedient so to do for maintaining supplies and securing availability and distribution of essential commodity, namely food grains, under the targeted public distribution system. This is the new concept under the National Food Security Act. Now, therefore, in exercise of the power conferred by Section 3 of the Essential Commodity Act 1955 and supersession of the Public Distribution System Control 2001. But this English suppression, it will be supersession. Second paragraph, third line. Except as respects things done or omitted to be done before such supersession and save as otherwise provided thereunder. So, anything done prior to coming into force this control order, that will continue. In otherwise, 2001 Central Control Order had been superseded.
Yes.
Now kindly turn to the next page. One proviso. Section 1, clause 1, 2, proviso. It shall come into force on the date of publication then, provided that provisions of this Public Distribution System Control Order 2001 shall continue to have effect as against the corresponding provisions of this order in any state which has not implemented the Food Security Act or is implementing the said act only in part. But this is the issue which has been considered by other division bench also. State's submission was before the coordinate bench that state has not fully implemented National Food Security Act. And in that case, 2001 is still in force. And relying on 2001, since 2013 control order has been framed, they can notify vacancy under 2013 control order. Our case is that National Food Security Act has fully been implemented by the state. So 2001 control order has no existence. And the moment 2001 control order supersedes by 2015 control order, automatically 2013 control order goes, and invoking any provision of 2013 control order, no vacancy can be notified.
Now, this central control order is of 2015.
My lord.
With effect on 20th March 2015.
My lord.
So your case is that as National Security Force Act has not been implemented in
Has been implemented. Our case is that it has been fully implemented. It is the state's case that it has not been fully implemented.
Has been implemented.
So 2001 control order goes, supersedes.
And consequentially
2013 order goes, because when they have issued the 2013 control order in exercise of the power under Section 3 Essential Commodities Act, read with 2001 control order. Your Lordship may come, just take a note of 2013 control order at page 209. Sorry, my lord, at page 1.
That 2001 notification 8th of March 2013 and 12th August.
My lord, just for a moment.
Those two has gone since the National Security has been implemented in the state. This is your argument.
Yes, because it says unless it is fully implemented, in that case 2001 will continue.
So this 2000, it was formulated in terms of section 3 of the section. Which section you said?
Section 3 of the Essential Commodities Act. Read with control order 2001. Just for a moment, if you like to kindly take note.
Essential Commodities Act.
Read with 2001 control order. Central control order.
Yes.
But for your lordship satisfaction, first kindly take up page 165 for a moment.
No, that you have taken us. That
So,
earlier you
Section 3, read with 2001 control order.
Now you said that state, the court, you were saying that a report was filed before the writ court. As regards
that I am coming.
Yes.
Some time may be given to me by, because some options have to be shown before your lordship.
You have shown that, Mr.
No. Subsequent thereto, some orders has been passed by this honorable court sitting in the division bench. That I shall place before your lordship.
That you have placed?
So, my lord, no, that I have not placed.
That coordinate bench order.
Justice Das presiding over bench, coordinate bench, passed an order in Duwari Reshort case.
Please.
Yes. So, my lord, up to that, my case is that 2013 control order became redundant. You cannot invoke any provisions of that control order. Now, your lordship, branch of writ petition has been moved. Order has been passed. If you lordship kindly turn to page 318. In all these writ petitions, interim order has been passed. So far the dealers are concerned not to deduct ration cards, and so far the distributors are concerned not to deduct the dealers.
Mr. One thing, you were saying that even if the new order is implemented, then also it should be done in accordance with law.
If the declared vacancy under 2024 control order, which they have promulgated on 1st of August 2024.
So this 1st of August 2024 control order was issued on the basis of the 2015, which came into
National Food Security Act and 2015 control order. Now they have complied by issuing a new rule.
That is 2024.
1st August.
Your argument was that if 2000 in compliance with 2024, if fresh vacancy is declared, you don't have any objection.
I have no objection.
Then please explain us that if the vacancy is declared on the basis of 24, and the vacancy as declared earlier, where does your grievance fit in?
My case is that I have made an infrastructure.
You are the
Existing distributor of the area.
You are the distributors and the fair price shop owners.
Oh, fair price shop owners.
You are representing both.
Yes. So far the distributors are concerned, some dealers have been tagged with us. So this is a three-tier system. Some dealers have been tagged with the distributors.
Dealers have been tagged.
And so far the dealers are concerned, some ration cards have been tagged with them. But I have submitted before Lordship on last occasion.
Distributors, please explain to us.
Just I am explaining. Three-tier system. Distributors lift their allotted quota of ration articles from the godown of the FCI or the state government godown. They lift it and store it in their godown, distributors. Then they distribute it to the dealers.
Tagged with them.
Yes. So if the dealers are tagged with the distributors, they will suffer for business. Volume of business will be reduced. On that count, distributors are coming, challenging the fresh vacancy in their location. Because if that particular gentleman is appointed, any person is appointed, some dealers shall be dealing from the distributors. And so far the dealers are concerned, if any dealers is appointed in the operational area of the existing dealer, ration cards will be detached from the existing dealers and it will be tagged with the new dealer. So volume of business will be reduced. and ultimately held that this scheme is ultra vires. Now kindly turn the page 35. This is very important. Paragraph 25. But Mr. Cord leading me in that case. That main thrust of argument of Mr. Cord, learned senior counsel, is that after coming into force the Central Government Control Order 2015, Rural Control Order 2013 and Urban Control Order 2013 have become non-existent, as the Central Control Order 2001 has been repealed by the Central Control Order 2015, hitting at the very root of the existence of Rural Control Order 2013 and Urban Control Order. Same issue. From reading of Central Control Order 2015, it is, however, found that that has been made in exercise the power conferred by Section 3 of the Essential Commodities Act in supersession of the Central Control Order 2001. In Clause 2 of Central Control Order 2015, it is specifically provided that provisions of the Central Control Order 2001 shall continue to have effect as against the corresponding provisions of this order in any state which has not implemented the Food Security Act or is implementing the said act only in part, which I have shown to your lordship from proviso. Learned Advocate General submits.
Why it is said from reading of the Central Control Order 2015, it is however found that it has been made in exercise of power under Section 3 and in supersession.
Yes.
Why in supersession?
2001. I have shown to your lordship 2001 has been superseded by 2015.
Yes.
But with saving clause, proviso that if any state implement. Then next paragraph. Learned Advocate General submits that taking into consideration the mechanism which has been provided in National Food Security Act and the Central Control Order 2015, like monitoring, etc., the NFSA Act has not yet been implemented in full in the state. It is submitted by Mr. Kaur, Learned Senior Counsel, appearing for the appellants, that NFSA Act has been implemented in full force in the state and thereafter only duration scheme was made. When Learned Advocate General, being the highest officer of the state and supposed to be in known the facts in submitting the National Food Security Act has not yet been implemented in full and in the state.
Mr. Shara, it is 18th status as on 28th September 2020.
Yes, what happened? Before the Supreme Court,
this was taken to Supreme Court.
Yes, state file a SLP.
Achha.
Saying therein the submission which has been recorded is not correct. Advocate General has never said that it has not been fully implemented.
Very good. But now today we are in 2025.
Same thing. Whether it has been implemented or not.
This is why they have used a report.
No.
Saying that
at that material time, this SLT has been filed in 2022 by saying before the Honorable Supreme Court
that this was a erroneous submission.
Yes, meaning thereby it has fully been implemented.
As
meaning thereby it has fully been implemented in 2022. On last occasion, I have placed before your lordship page 54, ground number R, from this voluminous SLP. May I hand over, my lord, the typed copy of that portion only?
We are accepting you.
No,
that
just
you will reply.
What is the content? This is the ground number R.
So your contention is in 2020-22, it was implemented
fully.
So accordingly, 2001 control order,
they cannot take advantage of the proviso, which says unless it is fully implemented.
Very good, but now they have used an affidavit. They are saying that only mere cosmetic changes are.
That is also in my favor, but that is not the act also. Why I am saying this is reforms part. Reforms is always continuing. Section 12, which as they have relied, I shall show to your lordship, which they have relied on.
Sure.
Kindly read, my lord, this paragraph.
Paragraph?
My lord, this only page, the ground art of the SLP. Entire copy is with me, but I am not handing over that voluminous copy. So this is the submission before the before the Supreme Court, that the submission which has been recorded by the division bench in duration scheme, that state has not fully implemented the National Food Security Act is not correct. Vice versa, state has fully implemented the National Food Security Act. That is my submission. The only case made out and I lost the writ petition on the ground that it has not been fully implemented. 3 issues has been framed, 2 issues in my favor. So far the other issue is concerned, issue number 2, the learned single judge held, since it has not been fully implemented, 2001 is still in force. Despite placing this SLP before the learned single judge. And that has been dealt with by the learned single judge. I shall show to your lordship. But SLP has been affirmed by the
Dilona, pencil, Dilona. Yes.
But SLP has been affirmed by the special secretary.
Very good, very good. Now let us come to the next one.
My lord, next. Now your lordship kindly.
So dual ration scheme was in
Declared
derogation.
ultra-virus.
No, that was in derogation to the targeted scheme or any.
2013. Invoking provisions of 2013, dual ration scheme has been framed. Numbers of grounds, it has been challenged. One of the ground was, you cannot invoke 2013 for framing dual ration scheme.
Yes.
The division bench declared ultra-virus to the dual ration scheme. But in respect of the ground, that whether 2013 control order was in force or not, says since the Advocate General submitted,
not implemented.
Subsequent thereto, Supreme Court.
So your ground stands according. It remains to be a redundant. Yes.
Now, on the same ground.
Show us that portion of that portion of the order of the planets. That is page 338.
Page just.
338, 3 questions frame.
Which that I'm showing you. It starts from page 329, 338.
Now 343 is paragraph 2017 was your.
But your lordship kindly turn to page 338.
338 our can go.
3 issues.
That you have showed us.
Then my lord kindly come to page 341.
341, yes.
Count number, my lord. First count has been in my favor. Page 341.
First ground is para 13.
My lord.
Second ground is para 17.
My lord.
And the third is para 21.
My
so
lord.
Which was against you?
My lord, kindly come to page 341. Last part from bottom, query number 2.
Query number 2.
This is the
This is against you.
Against me. May I read my lord?
Query number 2 is clause Roman 2 of paragraph 8.
Paragraph 13, query number 2. Yes.
Now para 14.
My lord.
Pardon?
All points have been argued on the other side.
Yes, Mr. Bandyopadhyay, we make our endeavor to cut short the learned council. We will immediately revert to. Order impugned. Paragraph 14 you have shown.
Yes, my lord. Paragraph 14.
Here, I am not available for every day.
Yes.
Paragraph 14, my lord.
He is available for every day here. I am not available for every day here.
But we have to hear the state, Mr. Bandyopadhyay. You will argue.
Hear this state, but the petitioners, if he argues for days and days after.
Give us 15 minutes, Mr.
Thereafter, kindly extend the interim order.
Yes.
Paragraph 14.
That you have placed, Mr.
Yes. So, your lordship just asked me where it has been dealt with.
Paragraph 14. We have
Paragraph 14 says, since the learned advocate for the state filed a notes of argument saying therein that it has not been fully implemented.
That is paragraph 17. That is what we were saying.
My lord.
Now, yes, anything else you want to show?
Next case, similar issue has been considered by a single judge. When the learned state advocate submitted before the single judge, it has not been fully implemented.
Why you are taking?
Yes, that same division bench says it is not proper. In dual ration scheme, you have said.
Where is that?
My lord.
That is the other coordinate bench.
Your lordship, keeps me according to my way. Otherwise, my lord.
We have allowed you the entire day, Mr. Sharda. You said that you will take 15 minutes.
But they have filed and my lord supplementary report on the last day. I have to deal.
Mr. Sharda, you conclude so that we can finish off the matter.
But kindly take this.
And you will get your chance in replies. Let them say what they have to say.
But if I don't place my case,
give it to him. Give the supplementary.
Yes.
Yes, what you are showing.
And kindly see the division bench
Any
judgment.
point left out, any point left out after hearing them, you point it out in your reply.
Possibly that would not be proper. If I not place this, they cannot reply. Give reply to this.
Yes, tell us what you have
But
placed.
kindly come to page my lord 6. This is the division bench, same division bench, beside our Justice Dash. Single bench. This is a single bench order. I'm handing over the division.
Why you are showing it to us?
Because this case has been dismissed on the ground, on the basis of the submission of the state, that it has not been fully implemented. Then appeal has been papered before the same division bench.
Give me some reference, something.
Yes.
A single bench to সব খোলা আছে। Single bench judgment
copy দেবেন একটা।
So these against this appeal, what has happened?
Kindly come to my lord. Second paragraph. Second paragraph.
Yes.
Kindly read my lord, paragraph page 2.
But why should we go into this? This is in your the writ court considered it.
Yes.
Impugned judgment.
Entire submissions, entire this judgment, all that has been recorded.
Achha, show us what you are showing.
From bottom, second paragraph.
In the appeal order.
Yes. While passing the impugned order. May I read my lord?
Page.
Page 2.
Yes.
While passing the impugned order, honorable single bench relied on the decision of this court.
Mr. Sharda, we understand your point. Your point is that issue has been reiterated here against which appeal has been preferred. Now in the appeal, this had been the observation.
Kindly one paragraph. Page 4. Kindly turn up.
Yes.
Copy of
Yes.
Page 4. This has been relied by the learned single judge. Page 4, second paragraph.
Copy, Mr.
Give a copy to him.
Your Lordship, I have no other copy. I am handing over this copy. Your Lordship, kindly read my lord. Page 4.
Page 4.
4. This has been relied. Just I am giving.
You read and hand over.
Taking into consideration the submissions advanced by learned counsel for the parties, we are of the view that there is clamor for illegality of the impugned action in view of coming into force. Kindly take note of the sentence clamor. Into force the Central Contract 2015, decided by National Food Security of so-and-so, the applicant being stated to be supplied of so-and-so, his document so-and-so. So observation is that there is a clamor. Declaration of vacancy under 2013 control order after declaration of redundant. That is the division bench. Initial observation, since Advocate General says, subsequently it was found, it was brought to the notice, Supreme Court separate submission, then the same division bench passed an interim order saying that it is not proper.
Now what has happened to this appeal?
Appeal has been subsequently withdrawn.
Withdrawn by whom?
By the appellant.
That is by your client.
No, I'm not my client. Mr. Dhara's client. Mr. Dhara is there.
Some other person.
Fine, yes. But now he is that side. He filed this case, madam.
Yes. All right.
Now, Your Lordship, kindly take the interim order passed by this division bench.
You have placed it, Mr. Sir. Let us hear them.
Only that.
Which one?
If Your Lordship not allow me to make my, because at least
Mr. Sharda, don't
20
say
to
this.
25 appeals are going to be disposed of.
So you only said you have concluded you will take 15 minutes.
Because I have to deal with their supplementary report. A new thing has been brought.
So deal with and finish it off.
As Your Lordship.
Come to the report.
Or kindly take up my report. Exception.
Your exception to the report affirmed on
before that, my lord, last report which has been
9 September 2020.
Kindly take up, my lord, their report. Their
9
supplementary report. First supplementary report.
When was it affirmed?
It has been affirmed on 10th March.
এটা কোথায়? 10th March.
Last day they have filed it.
10th March. এটা তো 9th September. তাহলে আরো দুটো আছে। A supplementary report in the form of an evidence on behalf of respondent number.
Last day they have handed over it. Yes. Page 3.
To this you have used an exception today.
Yes.
তাহলে এটা কি exception?
There are 2 reports and 2 exceptions.
আচ্ছা, one report affidavit in terms of an order dated
6th August.
26 September. This is one report.
First report, yes, yes.
This is the first report.
Date of affirmation.
Date of affirmation তোমার কাছে আছে?
13th day of August. This is the first report.
First report is in August.
13th August.
13th August of
2024. To that they have used an exception, then we have filed another one.
This is in terms of the coordinate bench order.
One is 5th November 24. One exception to the
Yes, that is the
affidavit
exception.
in terms of the order of 26.
That is the exception to the first report.
First report.
এটা তো 5th November.
Exception. First report 13th August 2024. Our exception 10th September 2024.
What is this affidavit in terms of order dated 26 September? What is this?
26.
Check it up, ওদেরকে দাও. And what is that? This is of November 23.
This is in respect of contempt matter.
But this is contempt. CPAN.
আচ্ছা, ওটা contempt লিখে রাখো তো, contempt ওপরে contempt.
Kindly first.
I have not got the report. 10th March.
10th March is the exception.
This is supplementary report.
Yes. That's the latest one.
Yes.
This is 10th March.
Second report.
Supplementary or second.
Supplementary or report?
Second report.
Second report.
This is second report on behalf of state. Now, where is the first report?
First one is
First report is
13th
August.
August. 13th August 2024. Right?
Yes. But it is styled as report in the form of an affidavit on behalf of respondent number 2.
13th August 2020. This is the second report.
13th August is first report.
Oh, sorry, first report.
And our exception is, my lord,
first.
9th September, I think.
9th September.
13th August is the
First
report.
9th September is the exception.
9th September is the exception.
First exception.
Achha. This is first exception.
My lord.
This is 9th August.
9th September. 9th September 2024.
9th September.
9th September 2020. Yes.
Then the supplementary report 10th March 2025.
Second report is
10th March.
To this, where is your supplement?
Yes. Our exception today I have filed. Affirmed on.
This is exception to second report.
My lord. April 2025.
Yes.
I have placed before your lordship the first report which says 98%, 99% in my favor. The second report, your lordship, kindly take up first. One paragraph, page 3, paragraph 4. Second report.
Paragraph
4, page 3. Report dated.
Yes.
March. It is stated. Have your lordship got money?
Second report, paragraph 4.
Page 3.
It is stated. Yes.
That as on 30th September 2022, that is the date of declaration of vacancy. 89.4%, kindly take note of. Ration cards have been linked with the Aadhaar cards. And on 30th September 2022, about 98.61% of transactions were being made through the Aadhaar-based authentication process. Photostat copy of the sales. Pausing for a moment, my lord, this tagging of cards with the Aadhaar number and distribution through EPOS machine are all part of reforms. This is not implementation. Implementation has been done in 2016. I shall show from the National Food Security Act. Section 12 says these are all reforms, which is a continuous process. For betterment of public distribution system, this continuous process will continue. This is reforms. Kindly take up my exception to the supplementary report. First, Your Lordship, kindly take up page 11. When it has been implemented.
Page 11.
Page 11 of my supplementary report. Exception. The supplementary. But this is a order of 22nd of January 2016 issued by the Director District Distribution, Procurement and Supply. Kindly see guideline of National Food Security Act and RKSOI. Dated so and so. Enclosed, please find here is the guideline of implementation of National Food Security Act and Rajya Khadya Suraksha Yojana going to be implemented with effect from 27 January 2016. Kindly take note of. 27 January 2016. Because, my lord, this tagging of Aadhaar number with the ration cards, distribution through EPOS machine, these are all reforms part. It has been implemented in 2016. Kindly take the next page. The guideline. First paragraph. Implementation of National Food Security Act will commence in all over the West Bengal with effect from 27 January 2016. Page 12.
So you are contending that these are all reforms? Continuing reformation is being made upon implementation with effect?
Absolutely. I shall show from the National Food Security Act 1 to 7 sections are all implementation.
Very good. Let us go to that.
Then other documents, my lord, may I show from this? Kindly come to, my lord, page 11 shown. Then, my lord, page 21.
Yes.
This is, kindly see, after implementation for using of the EPOS machine, 2019. Kindly come to third line, third paragraph. For useful implementation of EPOS machine, following points should be taken care of. First paragraph, second paragraph, then the third. One line.
Yes.
This is 2019. After implementation. Now, Your Lordship, kindly come to page 24.
Yes.
This is also EPOS machine in 2020.
Yes.
Installation of EPOS. Next page. Automation. These are all part and parcel of the reforms.
Yes.
After implementation of the National Food Security Act. Then kindly turn to page, this is very important, page 26.
Implementation was on 27 January 2006. Yes.
Now kindly just, this is very, very important, page 26. Why I am saying so? That even a Aadhaar number is not connected with the ration cards, persons are entitled to get ration articles.
We need not go into that.
As your lordship, as your lordship,
Sure.
as your lordship. So kindly then take up another National Food Security Act, one section.
That you have annexed.
Yes, yes. At page 209.
So the only contentious issue is as to whether implemented or not implemented. This is the only bone of contention.
So far the single judge order is concerned.
Yes, and if it has been implemented, then your stand goes upright and if it is not implemented, they are served.
My
This is the only.
yes, yes, absolutely. I'm grateful to you.
Very
This is the issue.
Yes, what do you want us to do?
Kindly, it starts from page 209, National Food Security Act. Kindly turn to page 211. For setting up fair price shops.
211,
my lord.
Yes.
Chapter 2, provisions for food security. Or segregation of cards. Identification of ration cards. Eligible households. These are prior to implementation.
Well, we didn't follow. What you said, paragraph?
What I say, my lord, before implementation, some jobs are there. What is these jobs? Setting up of fair price shops. Identification of eligible persons.
Yes.
These are all from chapter 2, 3, 4, kindly 5, then kindly come to 7 at page 212.
So these steps have to be taken prior to full implementation.
Yes. Then I shall show to section 12, which says reforms. It will be clear from section 7, page 212.
Page?
Page 212. Section 7, left-hand side, kindly take note.
Section 7?
Yes, of the National Food Security Act.
Yes.
Left-hand side, implementation of schemes for realization of entitlements. Have you also got left-hand side? Small word. Section.
Implementation.
Section 7, left-hand side.
7. Implementation of schemes for realization of it.
The state government shall implement schemes covering entitlements under the section 4, 5, section 6, according to the guideline, including the cost to answer. So the moment 4, 5, 6 complete implementation. That has been done long back. Now you will also kindly come to page 213, chapter 5. Which they are relying on in the report and the supplementary report, only relying on section 12. Kindly take note of chapter 5, reforms in targeted public distribution system. Have you also got it? The central and state government shall endeavor to progressively undertake necessary reform in the targeted public distribution system in consonance with the role emphasized for the act in this act. Shall endeavor to reforms, which is a never-ending process. These are, my lord, kindly see, doorstep delivery, transparency, leveraging other. Kindly come to, my lord, C. 12C, 2C, leveraging Aadhaar for unique identification with biometric information, entitlement and for proper targeting of public services. This is the reforms. How many cards have been seeded with Aadhaar number? How many persons are getting through EPOS machine? These are all, my lord, under reforms, which is never ending. This endeavor shall be taken by the state government and the central government for better performance of the targeted public distribution system. Diverging means continuation. What they are saying in the report and the supplementary report, relying on section 12 only. If you also kindly take up their first report.
Yes.
The first report says only section 12. And second report also seeding of Aadhaar number, distribution through EPOS machine. This is subsequent to implementation. Only for reforms, better performance.
Yes.
Well, may I hand over? Just I am concluding. 3 dictionary meaning. First, my lord, supersession. Handing over. What is the meaning, dictionary meaning of supersession? Kindly take note of that. Supersession. Supersede. Have you also got right hand side? Black.
Yes.
Supersede, I'm reading, my lord. Have you lordship got, my lord? Just right-hand side before supersede. Supersede, have you lordship got?
Yes, yes.
Obliterate, set aside, annul, replace, make void, inefficacious, or unless repeal. So, my lord, supersession, redundant, no existence, repealed. I have said, submitted before lordship 2015 control order says, superseding 2001 control order. And if 2001 goes, 2013 goes automatically. If the foundation goes, superstructure falls automatically. It is a settled principle. Now, my lord, the second meaning, I have shown to your lordship, my lord, leverage. Can take note of my lord, black dictionary. What is the meaning of leverage? Seeding of cards. I have shown to your lordship from section 12.
Leverage.
Leverage.
That is
the ability.
Section 12. What?
Section 12 of the National Food Security Act. 12 2 subsection C. Page 213. Page 213. Well, 2C. Have you also got? Yes. Kindly see the meaning, dictionary meaning. The ability to finance an investment with a small amount of one's own funds, such as down pay, with the balance with the total funds, the use of smaller investment to generate a larger rate of return through borrowing.
Likewise, the white one.
Kindly read my right hand side top reform.
So you're relying on black. Yes.
Reform means right hand side top. To correct, rectify, amend, remodel. It cannot be said, Malad, implementation. A thing is going on.
Unless there is implementation, how there can be reforms?
I'm grateful. These are my submissions.
Thank you. Yes. Who you will argue or Mr. Bandyopadhyay?
My statute, Malad, under challenge, Malad. My control order, Malad.
Yes, yes.
Malad, my learned esteemed friends definitely will start. No,
yes, Mr. You are for whom?
But standing council
You
is
are
arguing.
adopting his submission. What more submission you take?
Who is he?
No.
You are adopting his submission. Yes.
But if I
take your seat.
Only thing is that the state has not prepared any appeal. State has not prepared any
I'll
appeal.
address that point. I'll address that.
And another thing is that they filed
I'll
an
address
application
that
of vacating interim order before the learned single judge. That has been dismissed. None appear on behalf of the state.
Vacating of which interim?
Interim order before the learned single judge when there was an interim order.
Who, me?
State, sir.
In one matter.
In one matter.
State,
one matter.
State
filed an application for vacating interim order. Well, that I have annexed.
What was the interim order that will not be given effect?
Not to give effect or
not to finalize.
License, not to finalize.
Not to finalize.
Different types.
Okay,
in all together, there was an interim order in all the writ petitions not to finalize the selection process.
No, you showed us.
Oh, this is division bench, not to dealing.
আচ্ছা আচ্ছা
Not to dealing is the division bench.
Yes.
But that order will appear from page. That order will appear page 390.
300
I don't think anything turns on that.
390.
309.
19, 19.
Yes.
Your lordship has been
10 number 1 of 2023. This is a vacating application. Kindly turn to page 321. Last paragraph. Can 1 of 2023 has not been moved by the learned advocate on behalf of the respondents.
Yes, Mr.
But these are my subjects.
Now, my lord, my learned senior has shown the issues which were framed.
No, you first address us. How do you overcome paragraph 14 of the judgment?
But so far the original side matter is concerned, that is to some extent different. So far the original side matter is concerned.
I don't know. We are making our end.
14 is the quotation, my lord. Quotation.
Come to
14 is the quotation, my lord.
No, first.
But may I just come back, my lord?
17, perhaps 17. 17.
Replace it, please.
At the very outset.
Yes.
At the outset, the veracity and the effect of the ground taken in the SLP pending before the Honorable Supreme Court, being ground R at page 54, cannot be decided in the present writ petition. However, it is pertinent to know.
What is the veracity? Veracity that ground was not taken.
That ground was taken. That ground is a quotation, my lord. That ground, what ground has been placed before.
Your ground was that it has not been implemented.
It has, no, kindly seize the ground, my lord.
Yes.
Art in recording that it has been submitted by the learned advocate general that the NFSA had not been fully implemented in the state. It is not our ground that the NFSA has been fully implemented in the state. And my lord, we have filed 2 reports before lordship, my lord.
So if it is not fully implemented, how do you get the benefit of the proviso?
But it is.
If your contention is before the Honorable High Court, we said that the act had not been fully implemented.
But the ground is not that the state has fully implemented the NFSA, and that is consistent with the 2 affidavits.
This is English language, na? That is what we understand.
No, Malad, kindly see, Malad, the ground, Malad.
Sir, you read it.
I am reading it. I have a copy of it, Malad.
Yes, please.
I may read it, Malad. That the Honorable High Court erred in recording it that had been submitted by the learned Advocate General that the NFSA had not been fully implemented in the state. But the ground is not that the NFSA has been fully implemented in the state. That is not the ground. But kindly, my lord.
Yes.
Malad, this is absolutely consistent with the stance taken in the 2 reports before your lordship. Malad, even in the first report,
you restrict yourself to this because this has been.
Malad, there is 2
they
other.
have come up in appeal against this portion of the order.
Malad, if I may indicate, Malad, there are 2 other issues which are extremely important.
No. We are not going into those issues.
Malad, kindly.
What
kindly,
is the subject matter of appeal?
Malad, kindly bear.
Do you have any cross appeal?
It is not needed. It is not needed.
Not needed means what?
Well, I'll tell you, Lordship, Malad. But I'll tell you, Lordship.
You will tell us. Let us understand. You have not preferred any appeal.
No.
Does it mean that you have not accepted the order?
It does not mean, Malad.
How?
Because, Malad, the writ has not been decided against the state. There are observations in the order which has been made against the state. I am entitled, Malad, not to prefer a cross objection under Order 41, Rule 22, and your lordships under Order 41, Rule 33 has the power to go into all the issues which were there before the Honorable Single Judge. I am fortified by the decisions of the Honorable Supreme Court, Malad. Consistently, it has been held.
This is a submission which you are making at this stage, when you merely accepted the order and did not open your mouth.
Malad, this order is in my favor. I am not a person aggrieved.
On the other 2 issues.
On the other 2 issues, Malad, since the writ has been decided against the writ petitioner, I am not falling in the bracket of the person aggrieved who will prefer an appeal. But there are observations in the order which runs contrary to what submissions we made before the Honorable Single Judge.
Even without challenging the appeal?
Yes, Malad, I am fortified by judgment, Malad. If your lordship so pleases, I will start from there.
Yes, show us on. That is the contention.
Yes, Malad.
You first first advance your argument on that, then you come.
Yes.
Yes.
But kindly, my lord, first takes. But if I may place order 41, my lord, once. Order 41, rule 22 once, if
You
I may.
show us the judgment.
Very
Huh?
well. Very well.
You show us the judgment on that.
1994 2 tate. 1999 7,000. 1997 target. 1997. Well, kindly, if your lordship takes 1999, volume 7, Supreme Court cases, 435.
Paragraph.
Malad, paragraphs I'll place, Malad, 21 to 24.
Achha. Yes. Any other judgment?
Malad, I'll place, Malad, 3 more. Malad, kindly takes 21, which deals with the amendment of 1976, Malad, to Order 41, Rule 22. These recommendations of the Law Commission are reflected in the statement of objects and reasons for the amendment. They read as follows. Rule 22, that is as it stood before 1976, gives two distinct rights to the respondent in appeal. The first is the right of upholding the decree of the court of first instance on any of the grounds on which that court decided against him. And the second right is that of taking any cross objection to that decree, which the respondent might have taken by way of appeal. In the first case, the respondent supposed the decree, and in the second case, he attacks the decree. The language of the rule, however, requires some modification because a person cannot support a decree on a ground decided against him. What is meant is that he may support the decree by asserting that the matters decided against him should have been decided in his favor. The rule is being amended to make it clear. An explanation is also being added to Rule 22, empowering the respondent to file cross-examination objection in respect to a finding adverse to him, notwithstanding that ultimate decision is wholly or partly in his favor. Mukherjee J. observed in so-and-so that the amended Rule 22 of Order 41 of the Code has not brought any substantial change in the settled principle of law. It would be incorrect to hold that the explanation now inserted by Act 104 of 1976 has made it obligatory to file cross objections even when the respondent supports the decree by stating that the findings against him in the code below in respect of any issue ought to have been in his favor. A similar view was expressed by UN Bachawat in so-and-so that after 1976 amendment, it was not obligatory to file cross objection against an adverse finding. The explanation merely empowered the respondent to file cross objections. In our view, the opinion expressed by Mukherjee J. of the Calcutta High Court on behalf of the division bench in Nisambu Jena case and the view expressed by UN Bachawat in Tej Kumar in Madhya Pradesh High Court reflected the correct legal position after 1976 amendment. We hold that the respondent defendant in an appeal can, without filing cross objections, attack an adverse finding upon which a decree in part has been passed against the respondent for the purpose of sustaining the decree to the extent the lower court had dismissed the suit against the defendant respondent. The filing of cross objection after 1976 amendment is purely optional and not mandatory. In other words, the law is stated in Venkata Rao's case, in Madras Full Bench and Chandra Prabhuji case by this court is merely clarified by the 1976 amendment, and there is no change in law thereafter.
What is the next judgment you are doing?
Malad, the 2004 3 to the Well, my emphasis here is on that it's an adverse finding. It is not that the decree is against me. Well, if your lordship kindly take 2004 volume 3 SCC 214. Now get a copy. Well, kindly take paragraph 35.
Yes.
Paragraph 35.
On the same point.
Same point, if I may place it, it has been relied in a recent decision also, but I am not placing the recent decision. because that ultimately held that since a point of jurisdiction is taken. So I'm not placing the recent one, but kindly takes it. It is of some relevance here. Paragraph 35. Kindly.
This is identical to the earlier one.
Malad,
Without
this
filing
is,
cross objection, you can challenge.
it is not obligatory. It is not mandatory to file a cross objection.
Yes. Next, what you are saying?
But this 35 may be of some importance to me. Kindly, my entire control order is at stake. Kindly, permits me to place the control order. If it goes, the entirety of it goes. There is no severability here. But kindly. As my learned senior rightly pointed out, several matters are dependent on it. Paragraph 35, internal page 245.
Yes.
A few decisions were brought to the notice of this court by the learned additional solicitor general, wherein this court has made a reference to order 41 rule 22 CPC and permitted the respondent to support the decree or decision under appeal by laying challenge to a finding recorded or issue decided against him, though the order, judgment, or decree was in the end in his favor. Illustratively, see so and so and so and so. The learned ASG is right, but we would like to clarify that this is done not because of order 41 rule 22 CPC is applicable to appeal preferred under article 136 of the constitution. It is because of a basic principle of justice applicable to the courts of superior jurisdiction. A person who has entirely succeeded before a court or tribunal below cannot file an appeal solely for the sake of clearing himself from the effect of an adverse finding or an adverse decision on one of the issues, as he would not be a person falling within the meaning of person aggrieved. In an appeal or revision, as a matter of general principle, the party who has an order in his favor is entitled to show that even if the order was liable to be set aside on the grounds decided in his favor, yet the order could be sustained by reversing the finding on some other ground which was decided against him in the court below. Well, I'm pausing here for a moment. I was at this, issue number 1 and 3 has been decided against me. If I can demonstrate that if those findings are in my favor, and the issue number 2, which my learned senior is canvassing with your lordship, is in his favor, still the decision will be same of the honorable single judge. I am entitled to show that before your lordship. This position of law is supportable on general principles without having recourse to order 41 rule 22 of the CPC. Reference may be had to a recent decisions of this court in so and so and Banarasi versus Ramphal.
All right.
This court being a court of plenary, this is important, this court being a court of plenary jurisdiction, once the matter has come to it in appeal, shall have the power to pass any decree and make any order which ought to have been passed or made as the facts of the case and the law applicable thereto calls for. Such a power exercised by so and so and the court by virtue of order 41, rule 33. Thereafter, Supreme Court goes into its own powers. I will place a decision on order 41, rule 33 also. If, keeping aside the point whether it is obligatory or non-mandatory for me, it is open for your lordships also to look into all the points which were there before the honorable single judge. But before that, if I may place 1998, volume 7 SCC, 327. Para 12. Only it's a longish paragraph. I'll only place half of it, for your lordship's kind convenience.
Yes.
That is at internal page 333. Yes. Order 41, rule 33 enables the appellate court to pass any decree or order which ought to have been made and to make such further order or decree as the case may be in favor of all or any of the parties, even though the appeal is as to part only of the decree and such party or parties may not have filed an appeal. The necessary condition for exercising the power under the rule is that the parties to the proceeding are before the court and the question raised properly arises. One of the judgments of the lower court, and in that event, the appellate court could consider any objection to any part of the order or decree of the court and set it right. We are fortified in this view by the decision of this court in Mahan Dhangir versus Madan Mohan. No hard and fast rule can be laid down as to the circumstances under which the power can be exercised under Order 41, Rule 33 CPC, and each case must depend on its own facts.
All right.
The rule, kindly
the
up to
rule,
placetam D, if it is not important, I will not read it. Only half of it, up to placetam D. Kindly bears with me, The rule enables the appellate court to pass any order or decree which ought to have been passed. The general principle is that a decree is binding on the parties to it until it is set aside in appropriate proceedings. Ordinarily, the appellate court must not vary or reverse a decree or order in favor of a party who has not preferred any appeal, and this rule holds good, notwithstanding Order 41, Rule 33. However, in exceptional cases, the rule enables the appellate court to pass such decree or order as ought to have been passed, even if the decree would be in favor of the parties who have not filed any appeal. The power, though discretionary, should not be declined to be exercised merely on the ground that the party has not filed any appeals.
Yes.
This cannot disentitle me from your lordship's discretion to look into all the points which are available. And lastly, 1994, Volume 2 SCC, page 41.
1994.
Volume 2 Supreme Court Cases, page 41. Paragraph 14.
This will also you place in its entirety.
This is on Order 41, Rule 33. It is a very short paragraph. Para 14. Your lordships are the last court here. I'll have to exhaust myself. This is the most vital question. Issue number 1 is extremely important. But that is at internal page 47.
Yes.
This provision is based on a salutary principle that the appellate court should have the power to do complete justice between the parties. The object of the rule is also to avoid contradictory and inconsistent decisions on the same questions in the same suits. For this purpose, the rule confers a wide discretionary power on the appellate court to pass such decree or order as ought to have been passed, or as the nature of the case may require, notwithstanding the fact that the appeal is only with regard to a part of the decree, or that the party in whose favor the power is proposed to be exercised has not filed any appeal or cross objection. While it is true that since the power is derogative of the general principle that a party cannot avoid the effect of a decree against him without filing an appeal or cross objection, and therefore the power has to be exercised with care and caution, and it is also true that in an appropriate case, the appellate court should not hesitate to exercise the discretion conferred by the said rule. Therefore, my lord, in my humble submission, my lord, it is immaterial whether I have preferred the cross objection when the points are before your lordship, my lord. But on that note, my lord, if I may come back to my lord, issue number 1.
Yes.
Your lordship will, if your lordship kindly take the internal page 8 or page 338 in the stay application. Because, my lord, why I am insistent, my lord, on issue number 1? Well, because if issue number 1 is decided in my favor, if your lordships find that the answer to issue number 1 is incorrect in law, then the other questions become immaterial. If it is not a sub-delegation.
Place what you say. Page 338.
Page 338, my lord, issue number 1. The issue number 1 which was framed was that whether the State Control Order 2013 is a delegated legislation or an independent delegated legislation. This stems from the issue that whether the 2013 Control Order, which is under, not really under challenge, but which is said to be redundant, whether it is a sub-delegation of the 2001 Control Order, or the argument of the state that it is a delegated legislation originating out of Section 3 as a whole.
Yes.
Our argument is that Section 3 of the Essential Commodities Act is the fountainhead of the power. The 2001 Control Order and the 2015 Control Order both are delegated legislations under Section 3 of the Essential Commodities Act. The 2013 State Control Order, which is said to be redundant, is also a delegated legislation under Section 3 of the Essential Commodities Act. But if I may put it in other words, the 2001 Central Control Order, the 2013 State Control Order, and the 2015 Central Control Order all three are delegated under Section 3. My control order of 2013 is not a sub-delegation under the 2001 control order. But if your lordship kindly takes well, section 3 has been placed by my learned senior. I'm not placing it once again, Malad. But if your lordship kindly takes the 2001 control order once, that is at page 146 of the stay application.
Yes.
146, Malad, kindly take the second paragraph. This is the 2001 central control order.
Yes.
But kindly take the second paragraph. Now, therefore, in exercise of the powers conferred by Section 3 of the Essential Commodities Act, the central government hereby makes the following order. And thereafter, the 2001 control order follows. Now, my lord, kindly comes to the licensing provision. That is at paragraph 7, page 150.
Yes.
7, subpara 1, licensing. The procedure for issue of licenses or authorization of the fair price shops for the distribution of essential commodities under public distribution system and duties and responsibilities of the fair price shop owners shall be as per paragraph 5 of the annex C to the order. Now, this paragraph 5 is at page 160. Therefore, the procedure will be as per annex C 5. Now, kindly take annex C 5 at 160. What it required me to do?
Yes.
The state government shall issue an order under section 3 of the act for regulating the sale and distribution of the essential commodities. But it is not that the state government shall issue an order under this 2001 order. The state government will issue an order under section 3 of the act, because section 3 is the fountainhead of power. 2001 is only giving me a regulation how it should be. My power is derived from section 3 as delegated by section 5 of the Essential Commodities Act.
Yes.
Now, my lord, kindly take that my 2013 control order, which is said to be redundant. 165. Second paragraph. Now, therefore, in exercise of the power conferred by section 3 of the Essential Commodities Act 1955, read with the Government of India so and so, order GSR 630 dated 31st August 2001, the governor is pleased to hereby to make the following order. Therefore, this 2013 control order is deriving its power from the section 3 of the Essential Commodities Act directly, and read with the 2001 control order because it gives the guidelines which I cannot contravene. But the 2001 control order under Annex C 5 requires me to issue a control order under section 3 and not under itself. So, it is not a sub-delegation of the 2001 control order, but a delegation of section 3. I'm grateful to my learned senior. Delegate cannot sub-delegate it to me. My delegation comes directly from the statute, central statute. And, Malad, I can buttress that point, Malad, if your logic also takes the 2015 control order now. That is at page 227. Second paragraph.
Yes.
Can I take the second one? Now, therefore, in exercise of the power conferred by Section 3 of the Essential Commodities Act and in supersession of the PDS Order 2001, except as respect of things done omitted so and so. Therefore, 2015 Control Order is also deriving the power from that same Section 3. Now, again comes to the licensing provision of the 2015 Control Order. That is the 245, para 9. What this 2015 Control Order required the state to do, though it is not relevant for my argument, but kindly see the flow of power. Paragraph 9, the state government shall issue an order under Section 3 of the Act, but not inconsistent with this order for regulating the sale and distribution of the essential commodities. The 2015 order again does not say that you issue an order under 2015 Control Order. 2015 Control Order also requires me to issue a control order under Section 3 of the Essential Commodities Act.
So this ground you will take in terms of 4133.
4122.
You did not open your mouth before the court below. Where
We
is
did.
your argument before the court?
Yes, it is there, Malad. It is recorded. Kindly take.
Did you file any affidavit in
Malad,
the petition?
Malad, whether in
You have
Sitara,
not-
Malad, whether in Sitara we have filed or not, I will just check, Malad. Because there are a bunch of writ petitions being heard together. But this is a point of law, Malad.
So at the point of law, you can do anything. Say,
It is
ask
argued.
us.
Why it is
We
argued?
are asking you, you are not telling us.
Why is it
You have not been got the time to affirm whether there was an affidavit in opposition on behalf of the
Malad,
state.
this is argued, Malad. It is recorded, encapsulated
Have
in
we
paragraph
filed
13.
any opposition? We are asking a query. We are putting a question to you.
Malad, I'll just check, Malad.
As a
Whether in
senior
Sitara,
counsel, you are appearing and you are saying that I don't know.
Malad, in this matter, in Sitara, Malad, perhaps no affidavit has been filed.
So you show us the affidavit, you made a pleading to this effect, which you are now trying to re-argue
Malad, it is
by banking on the provisions that you, even without preferring an appeal, I
kindly,
can take.
Malad, takes the submission at paragraph 11.
We are
of the impugned
asking
order.
you, have you used any opposition?
No, Malad,
No
but this is a point of law which is argued before the Honorable Single Judge at paragraph 11.
Yes.
Kindly takes paragraph 11 of the judgment at 340 of the stay. It is not a new point I am arguing before Lordship, Malad. It was there before the Honorable Single Judge. Kindly takes from paragraph 9 onwards. Paragraph 9 at 339.
Yes. Again, you are repeating that, which you
Malad,
have
I have not placed, Malad, it was your Lordship.
You
He'll tell from your Lordship, Malad, whether it
paragraph
was before the
9
Honorable
is-
Single Judge.
Paragraph 9 is quotation of section 3, which you are re-arguing.
Yes.
Now. Show us as the provision has been quoted, where you have argued.
Yes. Kindly takes paragraph 10.
Yes. We go to which paragraph?
10.
Yes.
Upon bare reading of the aforesaid provisions, it manifests that Section 3 empowers the central government to make orders for regulating or prohibiting the production, supply, distribution thereof, trade and commerce therein, where it finds necessary or expedient so to do, for maintaining or increasing the supply of any essential commodity
Portion. Thus, there cannot be.
Thus,
any
there
quarrel.
cannot be any quarrel with the power of the state government under Section 3 is exercisable by the state government upon an order of delegation of central government under Section 5 of the Act of 1955. Mr. Bandyopadhyay for the state tried to impress upon this court that the government of India in exercise of the powers conferred upon it under Section 5 of the Act of 1955 issued the notification of GSR 800 declaring that the powers conferred upon it under Section so and so and so and so in relation to the foodstuffs would be exercisable also by the state government, and thus the control orders, be it Central Control Order of 2001, TPDS Control Order 2015 issued by the government, or the Control Order of 2013 issued by the government of West Bengal, are independent delegated legislation made by two separate governments in exercise of the power conferred under Section 3 of the Act of 1955. Then the finding at paragraph 13, which has gone against me. Upon bare reading of the aforesaid, it goes without saying that the State Control Order 2013 has been issued in exercise of the power conferred by Section 3 of the Essential Commodities Act and the GSR 630 dated so and so, issued by the Government of India so and so. Needless to mention that the State Control Order 2013 has been issued pursuant to the delegation given by the central government under the Central Control Order 2001. Thus, there cannot be any
So you are disputing this.
Yes, this particular finding, Malad, this is what is against me.
That needless to mention.
There cannot be any quarrel that the State Control Order 2013 issued by the state government has its genesis in Section 3 of the Essential Control Order and Control Order 2001 of the Government of India. It is relevant to note that the State Control Order 2013 never records it has been issued in exercise of power conferred by notification GSR 800 dated so and so. Therefore, the argument that the State Control Order 2013 issued by the Government of West Bengal's independent delegate decision is not tenable and acceptable. But this is the wrong interpretation, or if I may say so. GSR 800 is a delegation under Section 5. The power is under Section 3. Malad, the power of Section 3, Malad, if your logic kindly take Section 3 once. Kindly take Section 3 of the Essential Commodities Act and Section 5.
It is quoted, page 11, 339.
Malad, I think Malad, it is quoted in a curtailed manner, Malad. Very well, Malad. Very well, Malad. I'll place it from there, Malad, because subsection 2 might have been relevant for this purpose.
Essential
But kindly takes, Malad, I've got the book, Malad.
ছিল তো, তুমি তো আনিয়েছিলে। এখানে আমার বাড়ির চেম্বার থেকে এসেছে, দেখুন বই।
Power to control production so and so. If the central government is of the opinion that it is necessary or expedient so to do for maintaining or increasing the supplies of any essential commodity, or for securing their equitable distribution and availability at fair prices, or for securing any essential commodity for the defense of India or the efficient conduct of military operations, it may by order provide for regulating or prohibiting the production, supply and distribution thereof, and trade and commerce therein. Therefore, this is the fountainhead of power bestowed upon the central government only, which will be guided by 3 subsection 2. But from A to H is what may be provided for. Now kindly take section 5.
এটাই বোঝানোর চেষ্টা করছি। ওকে কষ্ট করতে হবে, এক্সারসাইজ।
But your lordship has taken well. Sorry.
মানে এটা তো ওর সাবমিশন, needless to mention. Issued by the government, needless to mention that the state control order has been issued. 30. Pursuant to the delegation given under the control order, delegation given by the central government under the central control order. Thus, there cannot be any quarrel that the state control order 30
The central government may, by notified order, direct that the power to make orders or issue notification under Section 3 shall, in relation to such matters and subject to such conditions, if any, as may be specified in the direction, be exercisable also by, then B, such state government or such officer or authority subordinate to a state government as may be specified in the direction. This delegation is carried out in GSR 800, as has been referred to by the Honorable Single Judge. But the Honorable Single Judge holds the point against me because 2013 controller does not talk about GSR 800. But my lord, that is not relevant.
The point is, this 2013
Control order
date is guided by 3.2,
by Section 3.2.
not by 5.
5 is my lord, all powers of Section 3 is of central government. It has to be delegated somehow. It has to be delegated. This power to delegate is in Section 5.
Yes.
All state governments, whoever brings out a control order in India, has to be through a delegation under Section 5. Either the delegation is under A to a central government officer or under 5B to state government. This delegation in our state, as far as we are concerned, is GSR 800.
What is GSR 800?
But GSR 800 is the delegation exercise of power under Section 5. It's a notification, my lord, as recorded by the Honorable Single Judge.
Where is that notification?
My lord, copy to nahi hai. But I'm not having the copy, my lord, but I have a soft copy, but I'm not having.
Show us that 2000, the control order of 2001. What is the preamble of that?
Yes, my lord, kindly comes back to the 2001 control order, my lord.
Page
146.
Yes. That is.
Whereas
you mentioned GSR how much?
800.
This is GSR 630.
This is GSR 630. This is GSR 630.
GSR 800 is pertaining to what?
Is a delegation to the state governments under Section 5B.
Anyway, what is the preamble of this?
But this is whereas the central government is of the opinion that it is necessary and expedient so to do for maintaining supply and securing availability and distribution of essential commodities under the public distribution system. Now, therefore, in exercise of powers conferred by Section 3 of the Essential Commodities Act.
So let us stop here for a moment. So this is being made as per the fountainhead of power of Section 3. And Section 3.2 does not contain any other provision to that effect you are saying just now. 3.2. 3.2, this delegation spoken of in 3 can be for the purpose of subsection 2.
Not only restricted to that, but yes, those which are contained in H, that is, my lord, that is
A to H.
Yes, orders thereunder may provide. It can be more than that also, but we need not go into that.
Find that.
But from the language of subsection 2.
Subsection 2 says without prejudice to the generality of the powers under
conferred by subsection 1, an order may provide.
So
A to H.
You are saying
we are in D. We are in D. For regulating by license, permits, and otherwise the storage, transportation, distribution, disposal, acquisition, use, or consumption of any essential commodity.
Very good. Now, then, what is your argument that 3.1 power which you have exercised, that power, as has been spoken of at page 146, does what? Does it render the delegation? Delegation is always subject to Section 3.
Yes. Well, my argument is that Section 3 gives the power to the central government to promulgate the 2001 control order. That is page 146. That is why the central government is a central control order. Same Section 3 gives state the power to promulgate their control orders after a delegation under Section 5.
Upon the state.
Upon the states. But the power remains at Section 3, delegated by Section 5.
2001 power, 2001 notification control order which has been issued.
Yes.
That is in sync with Section 3 of the Essential Commodities Act.
It is.
Very good. Now, if it is in sync with Section 3, then subsequently, after coming into effect of NSF Act, which you are taking us to the earlier argument, after NSF Act full implementation, that becomes redundant.
Yes.
What will be your answer to that?
Malad, once NFSA is fully implemented in any state,
right? So we were
2015,
at the inception, we put you this question that why you are wanting us to take to that issue. Delegation, sub-delegation, whatever it is dependent upon full or partial.
I'll tell you,
implementation.
Lordship, why.
No, no, Mr. Bandota, we are trying to understand.
I'm trying to answer the Lordship's query, why I'm taking your Lordship back to that argument.
We will go to your argument. We are asking you a question that if you say NSF has fully been implemented.
I'm not arguing. I'm saying it is not implemented.
I'm saying, I haven't saying. If NSF is fully implemented, 2001 becomes redundant.
Right.
So, if you can establish your case on that it has not been implemented, then we need not discuss the argument which you are placing now before us. As such, I don't know whether you.
I've understood,
You are very anxious to take us to the point of that delegation, sub-delegation. You kindly come, I can agitate that. First, we wanted to know from you that NSF implemented or not implemented. What is the clear picture?
But NFSA has not been fully implemented in the state.
Then you win the case. Then you win the case.
Also, as far as 2024, when the first report is filed, that is August 2024, report number 1, that gives the picture as on August 2024.
Right,
First.
right.
And the second report of March 2025, which relates the situation back to the position of the advertisement.
Achha, so your argument is that so far as page 339 is concerned, which you are saying as regards the state control order, is a delegated legislation or an independent delegated legislation. Court held?
Yes, my lord, I would have placed it in a manner whether it is delegated or sub-delegated, because in effect it becomes a, going by, my lord, what has been held by the honorable single judge, it becomes a sub-delegated legislation of 2001 control order. I want to put it in the same pedestal as the 2001 and the 2015 central control order, because then, irrespective of whether the 2001 is redundant or not, whether it is superseded or not, my 2013 control order survives on its own footing. Then the only question which will remain is whether it is inconsistent with 2015 control order, so that it cannot match up with the 2015 control order, and therefore those provisions which are inconsistent with the 2015 control order will have to go. But if my control order is not a sub-delegation of the 2001 control order, but what is falling from your lordship, my lord, when it is NFSA is fully implemented, 2001 goes and 2015 comes in.
You're saying that's not relevant at all.
Yes,
because it's
but
not as per the
no, my lord,
2001.
apropos to the query which fell, my lord, taking the situation that NFSA is fully implemented. In that scenario, why issue number 1 will help the state? That is what I am trying to say, my lord. Even if its NFSA is fully implemented and the 2001 control order makes way for the 2015 control order.
Let us understand which you are saying is a delegated legislation. Which control order?
3 control orders. 2001 central control order.
Yes.
2013 state control order. And 2015 central control order.
So if these are construed to be delegated legislation,
all under section 3.
All these are under section 3. So this is not an independent delegation, according to you.
It is not a sub-delegation under 2001 control order.
2013, according to you, is not a sub-delegation.
No.
So whether 2001 remains, doesn't remain, whether NFA
it doesn't matter to me.
Implemented, not implemented.
It doesn't matter to me. It doesn't matter. Yes. Yes. And for that reason, my lord, I placed that paragraph 7 of 2001 control order along with Annex 5, both of which required the state that you promulgate a control order under section 3, not under this control order.
What happens if the 2015 is not in consonance with your 2013? Then what?
It is. It is. I have no difficulty in that arena. Because after the 2015 control order came, we made several amendments making it in sync with the new control order. My lord, I had placed paragraph 7
Para 7
of the 2001 Central Control Order.
Page 146.
Page 150.
Yes.
I had placed this, the procedure for issue of licenses or authorization to the fair price shops for the distribution of essential commodities under public distribution system and duties and responsibilities of the fair price shop owners shall be as per paragraph 5 of the Annex C to this order. This Annex C is at 160.
Yes, that you have shown us.
That, yes. So it requires me, Annex C 5 requires me that the state government shall issue 160, 160. The state government shall issue an order under section 3 of the Act for regulating the sale and distribution of essential commodities. As opposed to, the language devised is not that the state government will issue a control order under this 2001 control order.
Come to page 155, Mr. Bond.
My lord. 155.
It says annex to the Public Distribution System Control Order of 2001.
Yes.
If this control order is superseded by the 2015 order, then I'm sure you're not arguing that the control order, the annex will remain even if the control order goes.
No, Annex C is gone. Annex C is gone. Annex C required me.
If that goes, then your paragraph 5 at 160 becomes equally redundant.
I'll tell you, Lordship. Paragraph 5 at page 160 required me to make a control order under section 3. Now, suppose 2001 goes, taking with it the Annex C. My control order still remains, which is under section 3. It will be inconsistent if the same provision is not there in the 2015 control order. But in the 2015 control order, paragraph 9 has the same provision that the state government is required to make a control order under section 3 of the Essential Commodities Act. Even the 2015 control order does not require the state to make a control order subdelegated under the 2015 control order. So my position as far as as far as the 2013 control order is concerned, it remains the same. But kindly takes this Annex 5, kindly reads it with paragraph 9 of the 2015 control order. That is at page 245, 245. This Annex 5
Exactly.
Para 9.
Yes.
But this is I'm reading from the 2015 control order. The state government shall issue an order under section 3 of the Act, but not inconsistent with this order for regulating the sale and distribution of the essential commodities.
Kindly come to page 228. Before you go to that argument,
My lord.
Page 228 proviso says that the provisions of 2001
shall continue to have effect.
So provisions will do. Now you are arguing that the control orders of 2013 were not in terms of 2001. It flew from the parent section 3. That was your argument.
But may I add a line to it, Mullah?
Yes. Yes, yes.
My argument is not that it is not in terms of 2001 control order. My control order is in terms of 2001,
very good,
but not deriving its power from 2001 control order.
But to that effect, that clarification ought to have been given there in the proviso. What does the proviso run? You are arguing.
But this is proviso to 2015 control order.
Yes, 2015 control order says that the public distribution system of 2001 shall continue as against the corresponding provisions of this order in any state which has not implemented the NFS.
Yes.
So this argument which you are raising, this is, if you succeed that it has not been implemented, why you want to give us trouble to go into that issue?
But because I needed to put your lordship through the trouble.
So that itself indicates, Mr. Bandyopadhyay, that why this inertia? Why you are turning your face from that?
I'm not.
So then you
That will
satisfy
turn
us.
on the facts of it, Malad.
All right, query.
But kindly takes my 2 reports, Malad. Kindly takes my 2 reports.
No, when you have started on that, finish it off on that. Your argument as regards delegated legislation
Is that all 3 are stemming from the section 3? All 3 are stemming from section 3. Therefore, my 2013
of 2001
one control order
remains.
it remains.
This is your, yes. What is your next?
Second argument is
yes.
that, Malad, assuming the 2013 control order is a sub-delegation of the 2001 control order, which is their argument. Then also 2013 control order is not obliterated by coming into force of the 2015 control order by virtue of section 24 of the General Clauses Act. Till another control order, another sub-delegated control order is not issued under the 2015 control order, the 2013 control order will survive to that extent it is not contrary to the provisions of the new parent statute. Now, Malad, section 24 is quoted in the Honorable Single Judge's order, Malad. I am not placing the statute. If your lordship kindly takes it.
Section 24. Yes, we have taken section 20.
Yes.
Section 24.
Section 24.
Of
the General Clauses Act. But it is also in the impugned order, Malad.
the
Internal page
one
21.
who issues can also take it back.
Yes, and now it is the continuation which is important for me. Because Malad, it says that where any central act or regulation is after the commencement of this act repealed or reenacted with or without modification, then unless it is otherwise expressly provided, any appointment, notification, order, scheme, rule, form or bylaw made or issued under the repealed act or regulation shall, so far as it is not inconsistent with the provisions reenacted, continue in force and be deemed to have been made or issued under the provisions of the reenacted unless and until it is superseded by any appointed notification, order, scheme, so and so. Therefore, Malad, so far as it is not inconsistent, my 2013 assumed sub-delegated control order will be deemed to be a control order under 2015 control order by operation of section 24. Next thing to this.
Yes.
It is quoted, Malad, in internal page 21 of the impugned order. Argument is there at
we have
para 28.
Yes. So your second argument is subject to your first argument.
It is on a assumed position of law that 2013 control order is sub-delegation under 2001 control order.
Yes.
But if your lordship kindly takes 2002 volume 3 Supreme Court cases 481 General Clauses Act.
This is on General Clauses Act.
General Clauses Act. 2 decisions, I'll cite. This section is quoted at paragraph 14. I am not troubling your lordship. Kindly takes 17, paragraph 17 and 26.
All right, we shall go through it. And what is the other
17 and 26. And the other one is 2017, volume 4, Supreme Court cases, 537. Paragraphs 21, 25, and 26. But this is a perimeter provision of the Tamil Nadu or ki Madras ki naam or UP General Clauses Act. UP General Clauses Act perimeter provision has been interpreted in 25 and 26.
Yes.
Now, my lord, kindly takes my two reports. Or kindly takes the second report first, my lord, because that gives the position as on the date of the advertisement.
First report.
Second report.
Supplementary.
It is named as supplementary report in the form of an affidavit on behalf of respondent number 2.
Yes.
আর দু তিনটে পয়েন্ট রাখুন মনে হচ্ছে 15 মিনিট তো লেগেই যাবে শুরু করে দিয়ে চলে যাবো
Yes.
Paragraph 3, page 2. However, the vacancy which gave rise to this list of the instant appeal was notified on 1st September 2022. Therefore, it is imperative to place on record the status of implementation of NFSA 2013 in the state of West Bengal as on September 2022. This aspect could not be placed in a report of so-and-so. It is stated that as of 30th September 2022, about 89.4% of the ration cards had been linked with other cards, and on 30th September 2022, about 98.61% of transactions were being made through Aadhaar-based authentication portal. Admixture has been given. The duty in so and so. It is submitted as on the date of the advertisement. NFSA was not fully implemented in the state of West Bengal. But that will also be true if your lordships take the first report. But my humble submission is that the position as on August 2024 is basically immaterial. Why I say that? Because by August 2024, my new control order has already seen the light of the day. 2013 control order has already expired. Only to the extent of the things done and saved.
So what is the difficulty in publishing the fresh vacancy?
There were interim orders saying that you proceed with the selection process, do not give final effect.
Very good.
Therefore, we have gone through the entire processes in many vacancies, not one or two. My learned senior is absolutely correct. But the impact will be on more than 200 vacancies. 150, let us take 150. That will be the impact on the vacancies where the state has proceeded, public time has been spent, persons have been chosen, but only the license has not been given. And your lordships know from the gamut of experience, this process takes a lot of man hours, expenses are there. It is not that we can take everything back. Then the Gitanjali judgment would not have, Gitosri judgment would not have been passed by the Honorable Supreme Court. But the state had cancelled 400 vacancies because of the NFSA. That was upheld by the Honorable Supreme Court at that point of time. But why I cannot issue another vacancy under the new control order may not be the issue here. This
is the issue.
For 2 years, this entire process has been undertaken by the state.
How long this ego battle will go on?
It is not an ego battle, it's a matter of public time and public money.
Today, if we hold in your favor also,
we will be able to give license, my lord. We will be able to give license. We will be able to issue license to the chosen ones.
So if either of you is unsuccessful before us, the litigation continues. You are right that the state has undertaken this, which will affect.
May I put it in this way? It is not that if another vacancy is issued. Kindly here's this response from me. If a vacancy is today, suppose we take back, we withdraw all these vacancy notifications and we issue afresh 150. There's also no guarantee, that those won't be challenged and there won't be any procedure. Giving rise to a new procedure, a new 3 forums of litigation.
No, why?
It has happened, it is happening. But as we speak, already there are 40 stay under the new control order.
New control order?
Under the new control order, certain vacancies have been issued, vacancy notifications. Those are also under challenge for other grounds, my lord. But my lord, whether the litigation will continue or not.
Vacancies have been published under in terms of 24.
Yes.
So you are wanting to conclude the backlog which has gone under the remaining.
2022 control order.
No, very good. You
Sorry, 2013 control.
Those vacancies are cancelled and is published in terms of the 24 control order. How will the state suffer? The expenses which have been incurred.
We will lose 2 to 3 years, which we have given during the pendency of this litigation. And after, my lord, coming to the second stage of the litigation, we will be again going back to the first phase if those vacancies are at all challenged, my lord. Your lordships, my lord, with the deepest of respect, cannot put an end to future litigation. Your lordships will not be able to put an end to a future litigation. Your lordships will not be able to put an end to future challenges, to future notifications.
Why not? Because the entire thing has boiled down to this
No,
notification of
the
24.
points are completely different. The 2024 vacancies are absolutely on a different plane. They are being challenged on a different plane. They are being challenged on a different point. In fact, my lord, only for your lordship's knowledge, my lord, there is a litigation challenging the virus of the 2024 control order also. But these will always be there. But my lord, the state action has to be, my lord, judged.
As regards implementation is that it has not been fully
implemented. It has not been fully implemented in the state of West
the
Bengal.
instances which you have shown shows that it is still due to be implemented.
Yes, at least as of August 2024.
Achha, but then what? Till August 24 when the new thing has come into effect.
No,
new
till
control.
August 24, when I say that, I mean till I filed this report of my lord, 13th August 2024. 13th August 2024.
So as on 13th August 2024, according to you, this NFS was not implemented.
Fully implemented.
Now, what is your answer to that argument that
Yes.
that is a reformation?
Yes, kindly, my lord, comes to, my lord, the NFSA Act, which is annexed to the stay application starting from 209. My short response to it is that it will be a misnomer to say that implementation ends in section 7. The entire act provides for implementation, my lord. It has to be read as a whole. My lord, if your lordship, for example, takes section 16, my learned senior's argument is that section 7 is the wherewithal as far as implementation is concerned, nothing follows thereafter. But can I take section 16? Every state government shall by notification constitute a state food commission for the purpose, monitoring and review of implementation of the act. Therefore, implementation will not continue. Then subsection 6 of section 16. Subsection 6 of section 16. The state commission shall undertake the following functions, namely, monitor and evaluate the implementation of the act in relation to the state, either suo motu or in receipt of complaint of so and so. Then C, give advice to the state government on effective implementation of the state. Then 24. 24. Obligations of the state government under chapter 9. 24 subsection 1. The state government shall be responsible for the implementation and monitoring of the schemes of various ministries and departments of the central government in accordance with the guidelines issued by the central government for each scheme and their own schemes for ensuring the targeted beneficiary in the state. But while we are at 24, kindly takes note of 24 subsection 5 subsection C. But the parliament has still not amended this provision, and 2001 control order still features in this provision.
What?
Till date. To kindly take 24 subsection 5, then subsection C.
Yes.
To establish institutionalized licensing arrangement for fair price shops in accordance with the relevant provisions of the PDS control order 2001. Because it is not redundant for all purposes. The parliament, even after the 2015 control order, 9 years have gone by. 9 years after the 2015 control order has come into effect, under which the appellant has laid stress. This provision is still not amended. It remains. Anyway, I am on the point of implementation. Then 25. 25. The local authorities shall be responsible for the proper implementation of this act. Then 26. In implementing the different schemes of the ministries and departments of the central government and the state government prepared to implement provisions of this act, the local authorities shall be responsible for discharging such duties and responsibilities as may be assigned to them by notification by respective state governments.
So your argument is when for proper implementation these provisions have been made, it needs to be construed that it has not been implemented as yet.
Yes, and that implementation per se is not restricted to chapter 2 as my learned senior has placed. Implementation is not implementation apropos to sections 4, 5, 6 only. 4, 5, 6 only demarcate that who are the beneficiaries.
Very good.
And section 7 only encapsulates the implementation of 4, 5. He is right in that. But the entirety of the act, implementation is not encapsulated in section 7. For that, the entire act is to be read.
All right. Yes. Sir.
Number according to the writ petitioner, 2013 control order has become redundant. No benefit under the 2013 control order can be given to anybody. That is his case.
That is his subject.
That is his case. Now, kindly come to page 288.
Who are you, Mr. Bandyopadhyay?
I am the, because of the interim order, I am not, yes, I am not, this delinking and my vacancy was under challenge.
So you were implemented by them or you got added?
No, I have implemented myself. I filed the vacating application before the learned single judge. Your Lordship was asking me the question to Mr. Bandyopadhyay that why is the affidavit? The court said this is a pure point of law. Let's go. And there's a vacating application. Is there some documents I had to file?
But vacating application was dismissed.
No. That is not our vacating application.
Your vacating application in connection with
the main writ petition.
There are 34 writ petitions. No?
No, I am only in this case. Sitara Begum, that what your Lordship is telling. No. This particular matter.
So there is a bunch of matters.
Bunch of matter. I am only in this matter.
The list of the Oh, you are only in
Sitara Begum's case.
You were implemented as a respondent in Sitara Begum's.
Sitara
You are respondent numbers?
Respondent number 7.
Acha.
Here we filed the vacating application.
That vacating application is here, Mr.
No, it is not an annexed. Yes, it is annexed.
In the step. Oh, very good. Yes, you want us to go to page
First,
280.
kindly come to page 288.
Hmm.
See the date. This is 7th October 2021. Long after the 2015 control order. C. Sitara Begum says offer letter for distributorship, memo number 2365 dated 22nd September 2000 of the Deputy Director with reference to your application dated 5th May 2021. Dated TTPS number so and so, dated 27 so and so for functioning as a distributor on compassionate ground at village and post office subsidiary location is hereby informed that you are being offered to act as a distributor as per terms and conditions in the West Bengal PDS Maintenance and Control Order 2013. Now, who is he? He is the beneficiary of the 2013 Control Order. You are therefore directed to furnish the following documents proceed further in the matter of issue of provisional license as per clause 27, subclause 1 of the West Bengal PDS Maintenance Control Order 2013. Who is challenging? He is the beneficiary of the 2000 Control Order and saying before this court, you see 2013 Control Order has become redundant. No body should be appointed after the 2015 Control Order has come. A beneficiary of an particular rules and orders and act or can challenge. On a very root of the matter. And kindly similar the date of his application, 5th May 2021, dated 20 and with reference to 5th May 2021. Therefore, he made
5th May, what is
2021. Kindly see with reference to your application dated 5th May 2021. He made an application, she made an application for appointment on compassionate ground
in terms of 2013.
2013 Control Order, 5th May 2021, he has. Now, the license which was granted to him under the 2013 Control Order, license life is only for 1 year. That's up to 31st December. I'll show the provision. 31st December of a year. And the license is renewable. And license is being renewed year-to-year basis under the 2013 Control Order till today. And he is enjoying the benefit of that till today under the 2013 Control Order. (2015) Control Order, my lord, there is no provision for appointment on the compassionate ground. See, my lord, how this appointment would be made?
In 2015, there is no compassionate appointment.
There is no problem. I will show to it, your lords.
Now then,
now, my lord, kindly come to next page, 289. There is an amendment.
Achha, then why you are in the stay application is of Sitara? Why your name is not there in the parties?
What is the name?
What is your name? The cost title.
Page 3. Kindly come to page 3.
Page 3.
Mohammad Basir Ali.
Oh.
Added respondent.
Sorry, sir.
No.
Yes.
Therefore,
next page 289.
No, 289 page. No?
You are.
No, sorry, my lord. Kindly no. See, my lord, I will show to your lordship, my lord. This is a different thing. No, so 289. Now, therefore, can he assail or not? Whether it is appropriate or reprobate. I will show the judgment later on. Kindly see the page 311. And in every cases, in the bunch your lordships will find
all are beneficiaries of
2013 Control Order, because after 2015, those who are appointed prior to 2015,
they have been continued.
They are continuing. Why? The license is being renewed, and renewal of a license means granting of a fresh license. That's the well-settled principles of law.
Then what is your argument?
My argument is that if you are a beneficiary of an act,
you cannot come and challenge that.
You can't come and challenge it.
Very good. Had it been a single now all the writ petitioners are beneficiaries of
all. Your losses will find some. All. And when I argued this point, before the learned single judge has commented, in view of the fact that it has been held that the 2013 control order will remain in operation, therefore this point is not required to be answered. But whatever Mr. Shrishchandra Bandyopadhyay has submitted on the scope of the appeal, etc., I am not going on that. In addition to that, I have filed a cross appeal. Every point which is required, has been raised, and which goes in a very fundamental in character that was required to be decided by the learned single judge.
Now, what is your cross objection? You have preferred that is in the list.
That is in the list. I will read below later on. Just I am giving your lordship first the whole scheme. Let's see the scheme. Not that from here to here, not that. I will show you. If 2015 control order is accepted, today there would not be any fair price of owner. I'll show it. And 2000, if we read with the National Food Security Act, only the Panchayat will decide, Panchayat will distribute, or Panchayat will appoint. I will show this scheme. There is no concept of fair price. There is no concept. I'll come, my lord. Kindly see. Now, my lord, see page 311. The point which was arguing by Mr. Shrishchandra Bandyopadhyay, kindly see, an amendment was made on 12th April 2022 as page 311. Whereas it has been considered necessary to amend the West Bengal Public Distribution System Maintenance Control Order 2013, hereinafter referred to as said control order, in the manner herein appearing, now therefore in exercise of the power conferred by Section 3 of the Essential Commodities Act, the government is pleased to hereby to make with an immediate effect the following amendment in the said control order. And this is, my lord, how the persons will be selected. Clause 26 of the 2013 control order has been amended. Selection of the distributors, etc. What is the process of selection? Now, therefore, what he was arguing, in addition to that, my lord, this is completely an independent provision. My lord, I will show your lordships the law that
which provision is independent? Which provision?
It is a delegated legislation, 2013 control order. Irrespective of the fact of the 2001 control order is there or not.
Where do we get that?
This is my submission. 2001 control order is a sub-delegated legislation, nothing more than that. 2001 control order is a delegated legislation.
Yes.
One fact, was not brought within the notice of your lordships by any persons that there was another control order of the state control order was in 2003. control order. Control order. There is another control order which is called West Bengal, this control order 2003. And after 2003 control order, the West Bengal 2013 control order came. Now, my lord, another part of the argument I will come later on, my lord. A delegated legislation is a part of a statute. Until it is declared void or ultra virus, it's a part of a statute. It has to be read as a statute.
Yes.
By even, my lord, I am going to argue this part, this take it my argument, even another delegated legislation cannot nullify a different delegated legislation. ওই আমার ওই কেসের জাজমেন্টটা আনবি, মনে করবি রাত্রিবেলা আসবে।
Be keeping it.
Pardon?
We are thinking when we will be keeping it.
Tomorrow?
Tomorrow we have another bench, Mr.
21st, 22nd, I will not be here.
The entry bonded are at 2 p.m. we have another, we just
In the morning, if your lordship permits, I can argue, I can finish it. Okay. Then next week, my lord. Keep it to next week, 23rd, 24th.
23rd এ কিছু আছে আমাদের বেঞ্চের? তারিখ নেই তো কিছু, আর ওই 23 তারিখ কি আছে বললে ওটা আছে কোনটা? Wanting to finish it off. স্কুলের মধ্যে Mr. Wanda, how long will you take?
Well, such a brilliant argument has been made by Mr. Sahara. I need some more time.
The things are going on in such manner
No,
that
no,
I
my lord,
have to deliver the
I have
judgments.
just now come for 5 minutes.